Lord, I may be pardoned, my Lord. Lord, item 1, I pray for 10 days after there is bereavement in my family, my Lord.
Okay, all right. Call up 2 weeks on the ground of bereavement.
Well, I pray for adjournment, item 1.
Yes, that is what. Yes.
Am I audible, my Lord?
We have given. Yes. Item 2. Item 2. Person. Item 3.
See, I pray.
May I please tell us? My Lord, my senior is in VC1.
What you?
Yes. Mr. Mahanti is in VC.
My Lord, I'm sorry, my Lord. I'm busy. It is, I am the respondent, my Lord. It is the government to it.
My Lord, I pray this matter will take next week.
Next week, get the request of AG. Yes. Yes. Item 4.
Obliged.
Also. Item 5. Person. Item 6. Item 6.
Madam, may I please?
Yes.
Madam, I am asking the Hon'Ble Single Judge. It is regarding the compassionate appointment.
Make use of your mic.
This is respect to compassionate appointment.
You can drag it near you. That way.
That's right.
Yes. Compassionate appointment.
Yes, madam.
What has happened?
Madam, the husband of the petitioner number 2, the respondent number 2, has declared disabled and he is out of service due to medical ground. And
Are those people compassionate appointment?
yes, there is provision. Yes, madam. Madam,
Read that rules.
provisions, madam. That is, madam, you are asking me. So,
Death is generally a ground on which compassionate appointment is given.
yes, madam.
But on disability also given.
Yes, sir. That is scheme. There is no dispute in that. Yes, ma'am. There is no dispute. Only the dispute in the respect of the fact that yes, she is allowed to participate in the written examination for the ministerial cadre. Ministerial cadre. She is unsuccessful in the written examination. He is offered to participate in the constable in the ground duty, but she refused. Several times has been offered to accommodate him
Her husband was a constable.
My lord.
And she applied for the head constable.
Yes, my lord.
For which there is a recruitment process in general,
My
in
lord.
normal course.
My lord.
But she was in rehabilitation. Despite that, she was asked to undergo the recruitment process with normal.
Not normal. My
Yes.
as per the scheme, he participated in the compassionate.
Participated is all right.
In the compassionate also, that is a suitability test.
She had no option.
He failed the test.
Suitability test failed.
Yes, madam. After fail, my lord, we offer her to participate in the ground duty in the constable, but she is refused. Several times, you are seeing several times has been what Hon'Ble Single Judge held by my respectable submission in misinterpreting so far the clause 6 of the rule. The Honorable Court, you also may kindly see the order.
Which is that paragraph?
Paragraph.
Clause 6.
Paragraph you page 19, you'll also make kindly see. Page 18, I beg pardon. By page 18, last line, you'll also make kindly see. Last paragraph. Therefore, the question falls to decide is whether subjecting the petitioner applicant or a written test in terms of standing order 5 of 2001 for a compassionate appointment would be valid.
After scheme came into force.
Much better. When you also make next page. Para 11, last 4 line, man.
As part of forwarding the country, mentioned that all the enforcement elements of the The definition of a dependent family member, legal participation and there is no CORAM. It is also not disqualification if we did not have the requisite eligibility qualification.
Not disputed.
Then requires the
It also not disputed with number of two.
does not have a requisite for case admission. Yes, issue emergent notice. Have you?
I am there.
Yes,
Yes.
yes, tell. You do not have, admittedly, you do not satisfy the eligibility condition.
That is the only point my lord have to see, and the honorable court has also held so.
If court holds, you do not comply with eligibility condition, how can it grant relief to you?
No, court has held there is no requirement.
There is no requirement.
No requirement of that facing a compulsory appointment to face an interview or the recruitment process is not required.
What is that condition number 2?
Your Lordship, clause 6, Your Lordship, may kindly see.
My lord, kindly see. Shall I give that entire document is in the repetition.
That Your Lordship,
My friend has said,
my lord, that I have, though I have readings as an annex, but this document has not been annexed to my writ appeal.
Give that.
It is there, Your Lordship, may kindly see.
That is the ground that you don't annex
That I
page 159 of
while my lord, reading has been annexed to the writ appeal.
No, at times it happens that even if it is not in the pleading, the document becomes part of the pleading. But if you do not annex,
This is a contrary perverse case.
it is there in
Exemption from the requirement of sourcing and applying test to those appointed on
Clause 6, my lord, the top one.
over which to be governed by the general order issued in this regard.
Clause 6 is the top of the, Your Lordship, may kindly see.
Presently, without the agency of the staff commission or the employment this procedure, that is without the agency of staff selection commission or the employment exchange. In case of compassionate appointment, there is exemption.
Exemption so far as it is the regular recruitment process, madam. Not that to suitably test cannot be constituted. Last month the eligible test, that is
Your case that she is not suitable.
yes, madam.
Why not suitable?
She appeared in the interview in the written test, but she failed. During this process, my lord, the department sought for his willingness to assess for the pre-assessment test for 15 days, my lord.
Whether requires deeper
my
consideration.
lord, my friend is saying the half truth. That is why I am to clarify. Thereafter, if my lord want that, I will place it. Everything. Kindly see what he is saying.
That requires deeper.
No, my lord, kindly see, because this is a compulsory appointment. The husband of the petition, he is also the opposite party. He is alive. But in a terrorist blast, he is a constable in the CRPF. In Jammu Kashmir, he met with that terrorist blast. He suffered with the multiple injuries and declared 100% unfit. He is now still also paid. 100% disabled. That is why the decision was taken by the board of committee they have and for the procedure that the wife will be given an appointment. And his condition, he was discharged from the accident was in the year 2007. And the disability, total unfit was declared after he was prolonged treatment in the hospital, the government hospital, in 2014. In the order itself, when they have discharged him, the condition they have imposed, the wife will be given a suitable appointment. Or the next of kin, not exactly wife. Next of kin will be given a suitable appointment. Accordingly, I have applied for. And I have applied for because he is a lady, only graduate, no other qualification. That he was consulted for the constable clerk, that is SC clerk, they are saying.
ground duty.
Her ground duty, clerk duty, there she was asked. There in the first instance, her claim was rejected on 21/5/2014 that there is no vacancy. That is Annex 8 to the writ petition.
On the ground of vacancy.
No vacancy. This ground, what my learned friend is now taking this, that therefore I have stated with due respect to my friend, half truth. It was rejected only ground, there is no vacancy. So she has to wait. Again, what they have imposed upon her, they force me to appear in a test, which is not required. As per because 2013, the government guideline has come, where there was a standing order of 2005/2001, wherein there was that compulsory appointment, they have to set the written test. But in 2013, which has been also superseded later on, In 2013, the DOPT issued that circular compassionate appointment, what he was reading to. There they says there is for the compassionate appointment, they need not to face a regular recruitment process or the test and all these things. She is to appoint it, otherwise the formality, whatever they require. So therefore, this written examination they have forced me to appear was not required. What they have done? They forced me to appear in the written test. Out of 200, they declare that you have secured only 50 marks. Therefore, you are unsuitable. That is why in the 3 occasions,
That could not have been done at all.
my lord, because my responsible submission is at the first instance, I have learned from my lord. Once they have accepted that I am to give an appointment, they have allowed that one ground is on vacancy. They cannot take a second ground. That is not permissible. Moreover, this class 6, what my lord, the honorable single judge has held, that is not required. That is why they have been directed that you go for an appointment. That is the only comfort. A person in a terrorist attack is soldier. That is my point.
My lord, you'll
He
make a
has suffered.
Let's respect, my lord. We have obliged for that. But you'll also may kindly see. We have repeatedly, you'll also may kindly see. Please, my lord,
Yes,
if
you do not provide the morale of other people,
my lord, you'll also be
here, please hear before jumping the bridge.
My lord,
There is something.
we bow down, my lord.
Kindly bow down.
You'll also may kindly see how many times we have offered him. Upon her.
No, merely offering is not the question.
That's not the question.
What is
Earlier
the-
you said vacancies are not allowed.
Yes, that is there.
And suppose if you do to the wives and widows like this, which police, which soldier will be able to fight for the country? This is not ordinary thing that he suffered some vehicular accident and there he had all this disability accrued. That is not the case. This is a case where he suffered disability during the combat. During the combat he has suffered it. And kindly see the effect. If other soldiers or other police people working in the frontier think, see, if something happens to us, the wives and children will not be looked after by the state. That very impression will affect their capacity, their inclination to fight for the country. Do you understand? Yes, it stands on a different footing. Not to be a civil servant. Straightway we would have agreed with you. This is the case where the police was injured badly because of the blast. And to his wife, you are giving the employment. Simply you should give employment. Because you say there is no vacancy. That means that, but for the vacancy, you would have been given the job. That is the impression you have given. Once you give that impression,
that procedure standing out of High Court of 1, the Hon'Ble single judge has held that as per the scheme of 2013, that is not applicable. But my respect, you will also may kindly see the how many times we have given after that. You not
you have said that.
My lord.
Many times you have given.
Well,
No,
but the only question is one that she cannot be strict to take the particular post, which is the head constable ministerial. That is also group B C post, and the constable so far as ground duty concerned is also group C post. We offer her.
1 second. She is entitled to, barring this, she is entitled to group C post.
My lord.
There is group C vacancy. Why not head constable?
But we are so far as she refused to join in the ground duty constable. That is the case.
No.
You also may kindly see.
There is other post now. Group C
My lord.
comprises of
Different post.
different posts.
Yes, madam.
Therefore, now the one particular post is available to her. That post she is entitled to. Why she should take the lower post?
My lord, group C is not that anybody will take the particular post, my lord.
That is meant.
In group C, that number of posts is there.
Correct. Why?
She can observe any of the post, my lord.
No, not like that. Not any of it. You are not the Maharaja of this country. You are only the department.
My lord,
The
of course.
department has to go on the normative basis. In fact, when There is one judgment of English court, which Maxwell on interpretation of statute says, where law provided for the grant of 5 acres of land, and the government gave only 3 acres. The English court said, there is 5 acres, you give that 5 acres.
My lord, judgment is also there in this bill.
You have to keep quiet.
Sorry.
You are not a good lawyer. See, there is, the court is in his favor and still he argues.
No, sorry.
Sit up. See, where it is not an ordinary case of civil servant working in revenue department, excise department, education department. These are the people who fight in the frontier of the country to save the borders, to save our people. We are all safe because there is somebody who is ready to lay down his life for all of us. That person suffered the injury, bad injury, became disabled, and you determined his service. Even there you want to click to the rule of which is very difficult.
With due respect, my lord, I bow down so far as we are grateful at the soldier doing at the border of the court. That is absolutely no quarrel about that, my lord. We are obliged for that, my lord. But fact making
Lower post.
not lower post, my lord. Exactly, I am to say, my lord. It is not the lower post.
No.
One can, she cannot specifically ask for that. This is I have to.
Because it is available. Because it is available. You cannot be that choosy.
The suitability is there once she is not able to suitable. I want to cite one decision that in that respect.
Will give that decision.
Regarding that suitability, it is exact that case. Of course, it is not to the defense criteria.
No, not a defense case.
No, it is. Just.
I will look into, no problem. If you take preparation, we always appreciate it. You have come with preparation, I agree. But question is,
On the first, bow down, my lord. I do respect in that respect. I taken that also to that happened that we are also mobilized for what we are as I mentioned well. But on behalf of my
client, because you are briefed for that, we don't object to that. You are going to argue.
But that point, the respect, my lord. So far as this rules is provided 5% of the direct recruitment quota for the compassionate appointment. That is there so far as the CRP person is concerned. And for that, my lord, number of applicants is there. We are taken considering them and observing in the different post manner. And suitability.
How many of them suffered disability during the combat? Where have you stated?
That
then we cannot answer. See, case to case, difference is maintained.
Kindly see para 7.
They are not answering court's question.
That has not done.
Dismissed, agreeing with the reasoning of the learned single judge. First. The respondent is none other than the wife of a police personnel whose services have been discharged, who is discharged from the service on the ground of disability, which he contracted during the combat. First of all. An appointment on compassionate ground amongst the combatants' service is much different from that in ordinary civil service. First of all, the soldiers and police personnel fight at the frontiers of the country for the benefit of the countrymen. First of all, they will be under the assumption that if something happens to their life or limb, the government being the welfare state would come to the rescue of family by offering some compassionate appointment or such other thing. First of all, if that assumption is diluted by technical stand of the state, stand taken by the authorities, that would discourage them from laying their lives or giving up their limbs. First off, that would enormously affect the morale of the force deployed at the frontiers. First off, this aspect has not been properly treated by the authorities while declining compassionate appointment to the respondent. And that itself would constitute a grave error apparent on the face of the record, which warrants invalidation of rejection of claim for compassionate appointment. Next point. The compassionate appointment schemes in ordinary civil service is one thing, and that in defense forces is another. First one, the technicalities which otherwise would apply to the former need to be relaxed in the later by very nature of by very circumstance. First, even this aspect has not been borne in mind while the authorities declined the claim of respondent for compassionate appointment. First, next paragraph. The main contention of the senior panel counsel appearing for the petitioners that whatever be the nature of appointment, some selection process would take place, and that the respondent was offered some post under the scheme, which was one of the posts in the cadre, and therefore petitioner, she cannot claim a particular post is bit difficult to countenance. First of all, ours is not a Mughal government, and it is a welfare state constitutionally ordained by the Bhupendra Hazarika versus State of Assam. First of all, if one of the posts in the cadre avails for being filled up, the authorities cannot say that they would fill up some other post in the cadre and not this. First, only an East India Company can take up such contention and not the welfare state. First, in the above circumstances, petition is rejected at the admission stage. Petitioners to implement the order of the impugned order of the learned single judge within 8 weeks and report compliance to the Registrar General of this court within 1 week next following, failing which stringent action may follow at the next level of the legal battle. Next.
Item 7.
Learned the final counsel cited decision of the apex court, and that would not come to the aid of these clients in as much as it was not a case of scheme relating to compassionate appointment in combatant forces, but in the police force of the civil police force of the state. That makes all the difference to the case. What else? Next.
Item 7.
Wait, please.
Yeah.
I am for the appellant to Board of Secondary Education.
Yes.
I am agreed with the order in Annexure 1, passed with the Honorable Single Judge. The case is that the respondent number 1 has applied to appear in the CT examination or training, and he is required to have the minimum qualification of HSC for appearing in the CT examination.
Appearing in
CT exam.
CT means
Certificate training.
certificate training examination.
Yes. Qualification for that is HSC certificate, high school certificate examination
HSC is a must.
is a must. That is the admitted case of either of both the parties.
Yes.
Now the point that came up for consideration is he passed the HSC certificate examination of Andhra University, not of the Orissa.
Is it HSC should be of this Orissa only?
Of Orissa only, because this examination is in Orissa, conducted by the board only. That qualification required is HSC passed by the Board of Secondary Education, Orissa. So when he applied, by applying that along with the Andhra University certificate, the application was rejected on the ground that the HSC of Andhra Pradesh is not equivalent to the Orissa.
Who took that decision?
Board has taken a decision.
Whether board has power to equate, not to equate?
Yes, there is an equivalency committee of the board which decides which of the certificates are equal. That is based on the subjects which they
study in that.
They study in that course, and subjects which are required to be studied in this course. This is the requirement. Then the petitioner approached, the respondent approached the honorable court. That's only now.
HSC secured in Andhra Pradesh is not equivalent to HSC
Of Odisha.
of Orissa.
Board of-
That's the ground.
That's only.
Learned single judge comes to the conclusion they are equivalent.
Kindly see page 20, paragraph 7, 7.1. 19.
Fine.
Start from page 19, part 7.
Yes,
Para
page
19.
9. Page 19.
Para?
Paran 7.
Seven, yes,
Page
yes.
19.
Page 9.
Having held
One
and
second.
count.
We'll read. What is the stipulation at Annexure A1? Equivalence of certificate is under Annexure 1.
I may clarify, madam. The institution was running in Odisha. At that time, the petitioner prosecutor study and passed on 7/6/1989 HSC examination from that institution, which was equivalent to the our HSC.
That was equivalent.
Yes, and there it was equivalent. But there
There is
is
equivalence.
that is their government. They have admitted that till 1988 it was equivalent was there.
Not it.
And so yes. They say that.
All right, you show it now. You
Yes,
said
so that I will clarify. Then she passed the IA examination from our
show first one, then speak next things. Don't waste time of the.
that is so far as the equivalence of a matriculation examination under is concerned, it is stated that the state examination was treated equivalent to that of this board up to 29/1988.
What is that? What is that document?
That is their document to the secretary. It was communicated to Secretary Board of Education to Deputy Secretary to Government.
That you had produced before the court?
That was their counter in the law.
They have produced it?
Yes, ma'am.
They themselves have produced?
Yes, my lord. And it is on the basis of a recommendation 92.
Why you do not give another copy to one of the judges? What kind of advocacy? Second-rate advocacy, if not third-rate.
It was in the record, my lord.
All right. If you want to back up on this, You should make it a part of record. At least you xerox of that. Are you so poor?
No, my lord, that is also recording there. That's why
Whatever you want to bank upon, you should try to assist that one. Turning the pages and pages, spending time.
record asini.
1988.
Yes, my lord.
Yeah, you did HSC when?
7/6/1989. It was retrospective. It was declared retrospectively from 88.
And up to 20 September 88.
88, my lord. But when the order was communicated, kindly see that in 98 the government took decision.
Correct.
Yes,
Government took that decision. The certificates obtained up to September 1988
yes, ma'am.
are equivalent.
Yes.
It does not say certificates obtained subsequently are also equivalent. Where is that?
No,
You obtained on
1989.
89.
89. I passed on 7/6/1989.
7/6/89 is yours.
Yes,
but
ma'am.
cutoff date is 20 September 88.
That order, your lordship, kindly see the order date.
Order may be subsequent.
Subsequent.
Yes.
After 11 years.
All right.
Your lord. And then I passed the petition, the respondent passed IA from Odisha, that is CHSC 1991. Then graduation, then MA also passed from the.
The question is not all that. You might have heard a doctorate from Harvard University. The question is whether your HSC obtained at the hands of some institution in Andhra Pradesh
No, Andhra Pradesh.
or here.
Here, my lord.
Here.
That institution is going on, they are running in Barampur.
You may have the branches.
No,
It is
how do you say?
HSC.
How do you say? This communication has been made in on 24/7/1998.
Yes, my lord. This combination of government took decision on
Correct, but you passed only in 7/6/1989.
89.
And this has been communicated immediately.
No, it had no complaint. That is 98, my lord. I passed in 89.
Anyway, but
On the
it
basis,
is that-
on basis of the recommendation given in 1992. Why it was happened, my lord? The Andhra University declared that the Odisha University is not equal, Odisha HSC is not equivalent. Thereafter, this order was passed.
No, but you do not fit into that parameter.
Your lordship,
Issued subsequently is true. It is with retrospective effect. If not retrospective effect, it is retroactive. That's all.
and thereafter, at that time, I have already served for less than 15 years. I was appointed as a Ganashikyak. And thereafter, when I participated all the training, thereafter, when I applied for the city course, which is required for my regularization, there in 2014, it was rejected after 22 years.
You were in service also.
Yes, your lord, sorry, in 2015, I was terminated on that ground. Since your certificate has been transferred,
You entered a service when? Entry point is what?
that is 26/6/2003.
26 2003. You were appointed as
As a education volunteer, my lord.
education volunteer.
Volunteer.
which became
Ganashikyak.
Then thereafter it was Ganashikyak. Your lordship, kindly see, it was I was giving in the before the launching of the date, chronological dates. Your lordship, kindly see that.
That again one copy.
Now copy is there.
Two copy.
I thought that the file is there, that's why I not went to Xerox. Your lordship, kindly see. 26/6/2003, after being selected after scrutiny of certificate, all certificates, the petitioner was engaged as educational volunteer in a Kakapala EGS center under Suroda block. The petitioner joined his duty. Then 31/3 it was closed. And thereafter, on 12/6/2008, being selected, the petitioner engaged as a Ganashikyak.
12/6/2008.
Yes, madam. Ganashikyak. Then in view of the letters of the petitioner joined in government PP school, Badavali. And there also my certificate was verified there. On then 26/5/2010, after considering the petitioner as a direct to join the distance education program for acquisition of certified teacher training from government secondary training school, Bhanjanagar. Accordingly, the petitioner completed the training. Thereafter, by the unnecessary aid, the petitioner was issued a certificate of performance and attended the petitioner has worked continuously for last 3 years and his performance is satisfactory. 4/2/2011, after the executive agreement with the Chief Executive Officer, Jila Parishad Collector, petitioner continued as the Governor Sikhyok and discharged his duties. And from that year, my lord, the then DIF school, now known as the DO, directed the petitioner to join the distance education program, and his name was allotted to secondary training school, Hon'Ble. The petitioner was relieved. Thereafter, 26/6/2011, the petition was issued with his certificate and he was relieved on 26/6/2011. And 22 years after they rejected my certificate.
Only you are continuing in the employment.
Yes, my lord. And in 2015, they terminated my service in view of the cancellation of my certificate.
Brother, justice of the case is loaded in his favor. Law in your favor. Justice in his favor.
1 minute only, I will say. All these actions, inactions, what my learned friend has pointed out, are by the state government. I am an examining body. I have been asked to conduct the examinations of the eligible candidates. HSC is the minimum requirement to pass in this certificate training course. That is not produced. I have not allowed it. What is the mistake of mine, Lord? Your Lordship will kindly consider, without CT training course, the other employments or other things may be permissible. That is not to do with the equivalency with the HSC of Odisha.
But consequently, if your stand is accepted, if you lose, breadwinning also he loses.
That is, he has joined in the teaching post much later, my lord. Earlier, whatever it is there, where requirement is there that CT certificate is required, he has to obtain it. And therefore, he was removed because he couldn't get that certificate.
Removed after how many years?
That is by the state government. Man.
Correct.
Quite correct, man. Your Lordships are right that he was in employment and he got it.
It was in employment since 26/6/2003.
Yes, my lord. I don't say, I can't stand to say that HSC certificate of Andhra Pradesh is not valid for all purposes.
Not equivalent.
Not equivalent to the Orissa, and therefore he is not eligible to sit in the CT examination.
What CT examination is required?
The training course, my lord.
For regulation of their service as a regular teacher.
So that is the requirement.
The CT training, you will not be inducted as a teacher.
Yes, yes.
That's why I will remain as a Governor Sikhyok. Because for Governor Sikhyok, CT training was not required.
Wherever it is
required, a number of candidates along petition were directed to complete CT so that they will be absorbed as a regular primary school teacher.
As an exceptional case.
And exceptional case, my lord. In the meantime, my lord. Yes, fine. In the meantime, also, this
HSC
certificate is not required, IA is required. Yes, ma'am.
Why can't you go for some advocacy training? We are asking a question which may be you are coming in the way. You are having put in so many years of practice. Advocacy is something else. Yes.
Last may fix up a short date. I will apply your Lordships about the.
You have argued now. It's no question of
Yes, yes, absolutely correct. Absolutely correct. Well, your Lordships are saying that an exceptional case is.
This will not become a precedent for rest of the case.
Open a floodgate. That was my apprehension.
That's the reason.
But one candidate passing or not passing is not very concern of the institution, my lord.
But we decline indulgence because writ court is a court of equity. It is not only court of law, it's a court of equity.
Correct.
If the impugned order, regardless of arguable infirmity, has brought about an equitous result, that is a ground for declining interference in intra-court appeal. Intra-court appeal, writ court, law is one factor. Equity is also there. And denying that benefit to him will be highly iniquitous and therefore contrary to law.
I appreciate one aspect of the matter. You also see, so far as the Board of Secondary Education is concerned, the present appellant, there was no fault or not that he has approached it any time. We have accepted at one stage and now denied, not that.
Mr. Rao, we fully appreciate your stand of law, it is like Merchant of Venice by Shakespeare, where Portia will say, 1 pound of flesh, but not even a drop of blood. You take a contract is 1 pound of flesh. You take 1 pound of flesh, I'll allow you, but you are not supposed to shed 1 drop of blood. That's how Skylark was threatened. That will happen here.
That is how we are happy with the opposition here in this court. my humble submission will be,
Equity is heavily loaded.
your lordships have seen that paragraph 7 and 7.1. There, because the communication was given, merely because the communication is there, if it is not equivalent, it doesn't become equivalent. That is what my stand is.
Correct. That contention can be taken up in a particular time frame, not at this length of time.
May I suggest one thing? Your lordship may direct the authorities, as in other cases, your lordship directed that a lenient view to be taken, and we have in fact taken. Such like direction will be there.
No, then if you reject, again he has to come there. We can't depend on that.
I will accept.
We are not that governor, that good governor.
No,
Really.
your lordship's observations in such a language, it automatically impresses the authorities, which I did it in the past hours.
We have great respect for you. In fact, that's another thing.
But I am only apprehensive. I am not a student. Apprehensive that if some judicial order is passed, this will be cited time and again.
No, therefore we will say, we will
In spite of that,
apprehension.
in spite of that, in our experience, we have seen that all right, that in an exceptional case it can be done will be the precedent.
No, it will be not personal.
No, we'll say that this will not be cited as a case of precedent in any other case. Though Rupert Cross in precedent in English law says, the court which is rendering the judgment cannot say whether it has presidential value or not. It is the court before whom that judgment is cited that will decide. But we have departed even in case Vananda. The Justice Honorable Chief Justice Sikri has laid down the ratio to which 9 judges signed and 4 did not. But that became the law in Indira Nehru Gandhi. So we do not strictly go by what English law of it is. The objective Indian law of it is a case of equity.
Pardon, my lord. He has already appeared the city examination, and this honorable court by interim order directed to publish his result in body that was not result published. That's why the honorable single judge are directed to publish his result.
Interim order was passed, we have allowed him to appear in the
examination.
Thereafter, there was a direction to publish the result also.
Yes, also.
Once
this interim order is that to publish the result, and therefore I am here.
Interference declined in this intra-court appeal, broadly agreeing with the reasoning of the learned single judge, and also keeping in view the equity loaded in favor of the respondent who was the writ petitioner before him. First off. Next point. The apprehension expressed by learned senior panel counsel appearing for the appellant that this case would case has the potential to be cited. The judgment in this court case has the potential to be cited in other cases, and that would create difficulty, can be addressed by observing that this decision is rendered in the peculiar fact matrix of the case, and therefore apparently it does not have precedential elements, and therefore cannot be cited as a precedent in any other case. Dismissed. You copy of this one.
Yes, yes.
Your lordship.
Refer to, one second, refer to, give Xerox, take Xerox from the clarificatory letter dated 24/7/1998, where equivalence was declared, although for the certificates that were obtained before 2/9/1988.
29.
29.
What is now?
29.
I think.
20 before 27th, you can do it. 27th, you can do it.
27. Not 2/9/88.
27.
Discuss about this.
May I pray one thing?
Yes.
Your lordship may give me some time to comply the direction.
Order.
Because
So much bigger that period is going.
because
How much time you need?
2 weeks more.
On the request of learned counsel appearing for the appellant, a period of 3 weeks is granted to implement the mandate of the learned single judge.
The content proceeding is there, that's one.
Take it. You that along with that one, Item 8.
May I please, your lordship. Writ appeal has been preferred against the order passed by the Honorable Single Judge on dated 24/11/2025.
Discuss equity. Yes, sir.
Well, it's in the application, the transfer order of the petitioner was challenged. The transfer order was issued by the opposite party number 3 by violating 2021's regulation. Well,
One regulation.
yes, regulations, the reservation and other concession for the person with disabilities in various posts or services under the state government or public sector undertaking. Well, it's
Actually, these regulations are promulgated under which act?
well, it has been Right of Persons with Disability Act 2016.
What the regulations say?
Well, it's bare perusal upon clause number 17 substantiates that a candidate having disability must be appointed and transferred to their native places or to their native district. Now, Mallards, the petitioner's native place is Kakatpur and native district is Puri. But the petitioner was transferred from District Planning Monitoring Unit Jajpur to Keonjhar, which is violating of 2017. Mallards, what happened is on the instruction which was submitted by the opposite party number 3 on dated 22/11/2025, they agreed that they are bound by the regulation, but they transcribed that the petitioner's native district is at Jajpur and Kakatpur is adjacent to Jajpur, Keonjhar is adjacent to Jajpur. Therefore no discrepancy has been committed. But it is absolutely erroneous. In the writ application only at the page number 25, petitioner's service book is there. In that it has been transcribed by the opposite party number 3, who is the appointing authority, that petitioner's native place is Kakatpur and native district is Puri. Now, for that reason,
Sorry, when you have made a sentence,
yes, ma'am.
there is no full stop at all.
Sincere
At
apology.
least comma, give us comma.
Sincere apologies.
We have to assess, no? Each sentence, we have to scan what you are saying is true. Does it fit into parameters of law known to us? These things we have to do. Therefore, pause. Bhagwan Rajanish would say, pause is a very important part of the speech. There should be pause after making one statement. Since communication happens, you should give the listener an opportunity to assess what you are saying is true or not. Is it not?
Yes, ma'am.
So you are from which district?
Mallards, my district is Puri.
Puri.
Native district, yes, Mallards.
So your transfer is to which district?
Keonjhar, Mallards.
Huh?
Keonjhar.
Keonjhar. Different district.
Yes, Mallards.
That is impermissible is your version.
Yes, Millets, there is a small discrepancy I would like to suggest. I was posted in Jajpur. Thereafter, I was transferred to Keonjhar, which is violative of 2017 regulation, Millets. That's why 2017 regulation suggests two things. First, a person with disability, I'm a case of locomotor disability with 45%. A person having disability must be transferred to their native places. In his
native district.
Yes. Now, Millets, I am transferred to altogether a different place, which distance is 285 feet.
Yes, yes, Lordship.
What's your
Your Lordship,
what the learned single judge? It's a writ petition.
Yes, Millets.
it's a writ of appeal.
It's a writ.
Writ petition, dismiss, then writ appeal.
What is that writ learned single judge say? How learned single judge treated this argument?
Millets, in the argument when it was cited that no, the instruction which suggests that my native district is Jajpur is erroneous, learned single judge suggested no, it is not the case, and as the instruction has been produced and it has been transcribed that Jajpur is the place, Jajpur is the correct place. Our pleadings, our arguments were disdained, Millets, at that point of time, and an order was passed.
So where is that? Which paragraph?
Millets, 3.2, page number 25 of my writ opinion.
No, impugned order.
Millets, an order starts from page number 24. The relevant portion of the order is 3.2 onwards. If the Honorable Court permits, Millets.
It is not disputed that petitioner belongs to the district of Jajpur.
Yes, Millets, but unfortunately it was transcribed thus.
Consider the fact that to provide the instruction having that okay, having dispense it that personal appearance. This person
He was asked to appear personally.
Yes.
Why you did not? You were given. You undertook to produce him on 29, 17/9, 13/10.
Millets, this is
30/10.
respondent number 3. Initially, Millets.
No, we are asking this question. A single judge observes at para 6 that you had agreed to place him in the court. He agreed to appear before the court on these days.
No, Millets, it is not the petitioner who is the current appellant. It was the opposite party number 1, who is the respondent number 1. His personal appearance was desired by the Honorable Single Judge. And thereafter, the opposite party number 1 failed to appear at such and such date.
So 5,000 rupees fasting.
What is it, madam? Yes, Lordship may see paragraph 4 of the single judge judgment, Your Lordship. There it is the contention of the petitioner counsel. There he has not said that Puri is his native place. I need to stay in Puri or in the district of Puri. I need a posting. Now he's been posted in the district of Jajpur, which is miles away from the district of Puri, Your Lordship. It is not adjoining to the district of Puri, his native district. He never raised any objection being posted there. Now, Your Lordship, he's been posted to Keonjhar, which is the adjacent district to the district of
Judge. Does not say adjacent.
Your Lordship may see clause 17, Your Lordship.
Clause 17 of?
Yes, of the resolution, Your Lordship. That is page 36 of the writ application, Your Lordship.
Page 36
of the writ application, Your Lordship. He has not annexed it.
In the writ application, it is.
In the writ application, Your Lordship.
Go to writ petition. Paragraph?
Page 36, Your Lordship, clause number 17.
Or 17.
Yes, Your Lordship.
Posting or transfer of employee with the disability.
Yes, Your Lordship. On the background, he has been posted to Keonjhar.
No, let us read
the promotion, Your Lordship.
You asked us to read
Yes,
this.
yes. One, Your Lordship. The employees with disabilities should preferably be posted or transferred near to the native places, or at least in the native district, subject to administrative constraints, Your Lordship. Subject to administrative constraints, Your Lordship. So initial appointment is also not in his native district or native place, Your Lordship.
It is not in a mandatory terminology. Preferably.
Millets, if the Honorable Court permits, Millets, first of all, It is not mandatory, I understand, but there are, my lords, vacancies there. Point number one. Point number two, my lords, 286 kilometers. I have been treated in SCB, medical hospital.
But in other words, if vacancy is available, you are saying rule becomes mandatory.
My lords, no, my lords, I do
The
not.
text of the rule is apparently does not give scope for its being construed as mandatory. Now you say post is available, vacancy is available.
My lords,
Then it amounts to saying wherever vacancy is available, rule should be construed as mandatory.
no, my lords, the interpretation on my context, my lords, I interpret it in a different way. If the Honorable Court permits, the employees with disabilities should be preferably be posted or transferred near to their native places, or at least, my lords, in their native districts.
Subject to administrative.
My lords, so this rule is dissected into two parts. First, it says native place. If not native place, at least in their native
You mean to
district.
say the word preferably
Yes.
does not govern the second part?
My lords, I say both are independent. It says preferably in their native places. But if native place is not having, supposedly there isn't any office in which the petitioner can function.
No, if then this is not their question,
Yes,
is not
my
valid
lords.
at all. It is
Or at
impossible.
least, in their native district. Because, my lords, what happens is when a person is having physical disability, he or she cannot move that easily as compared to other person who aren't having a physical disability.
Only once.
My lords,
It is only once for taking charge of the office. It is not that you are completely always put on wheels.
my lords, I haven't taken advantage of this. My lords may see that when I was posted with Jajpur, I used to manage from Jajpur to SCB Medical College, Medical Hospital. I used to conduct my treatment. I have a problem of stiff spine. Now, so subsequently, my lords, then when the kilometer enhanced to 290 kilometers. So, my lords, 290 kilometers is not pragmatic for me. And thereafter, my lords, what they have done?
The treatment which you are taking, is it not available here?
No, my lords, it is not available.
Is it true?
That I cannot see, Your Lordship, have to take.
Where have you taken up that contention?
My lords, this contention, my lords, this contention has been transcribed in the writ application. Subsequently, there is also what happened is opposite party number 3 had issued a notice to SCB Medical College to substantiate that whether the treatment is available in any other hospital or not. It was denied. My lords, I have that, but I have the soft copy. If the Honorable Court permits a passover, I'll produce the hard copy as well. It is there as.
Madam, he is saying he has some health issue and the treatment is not available in the place where he now transferred to. Even then, you can see.
Your Lordship may give me a week's time, Your Lordship.
What?
I will go to the
No,
office
this is-
and find out whether the treatment is available.
You have said that it is not available. He has a soft copy. Why he will lie? He has a soft copy. There is no reason why lawyers will lie. Whether the government lawyers or these lawyers. They will
Yes, Your
not lie.
Lordship.
Did they say in their counter affidavit anything?
No, my lords, no counter affidavit was filed, only instruction was produced. After it
produced.
No, the opposite party number 3, who is the respondent number 3, produced the instruction after repeated.
Your Lordship.
You won't even.
Only instruction was there. In that they didn't touch this. But my lords, I have the soft copy. If the Honorable Court permits, I can submit before the Honorable Court. I have to just take a printout. My lords, a passover.
Take a care of.
Take a picture of that.
They help him.
Pending my phone.
Along with that, give 100 rupees.
My lords, may pass it over. There are several documents. I'll just see and I'll submit immediately.
Pass. Item 9.
May I please, Lordship, kindly permit me to appear through online. This writ appeal is preferred against the order passed by one of the honorable member in this division bench in writ petition number, Lordship, 26402 of 2025, Lordship, that is passed on 21/11/2025, Lordship.
Maybe placed before any other.
So it has to go before. I cannot. I am one famous saying. Do you know in English law, appeal Seizure to seizures, why?
Lordship, but the appellant has no objection, Lordship.
It is for me only. From seizure to seizure only. Impugned order is passed by one of us into brackets KSDJ bracket complete, and therefore the registry to post it before a bench which does not comprise KSDJ.
Item Lordship.
Yes.
Item 10. But I may permitted to play this matter. Here, Lordship, perhaps Lordship has rendered a landmark judgment, so the larger bench is concerned. Section 24(2)(c) is mandatory, Lordship, while issuing no confidence vote on Gram Panchayat matters, Lordship. So 24(2)(c), while serving the notice on the person concerned, resolution, proposed resolution, along with the requisition, notice, and granting 15 days, the three requirements are mandatory, Lordship, is held in judgment, Lordship. In this particular case, Lordship, the resolution requisition has never been served on the petitioner. That has been observed by the Honorable Single Judge. And Lordship, clear 15 days in judgment also reflects clear 15 days also not also there. And despite that, Lordship, because of the knowledge, the entire judgment says because the petitioner has no knowledge, he is never prejudiced because he can appear in the meeting and he can address the meeting. That is the entire substance of the judgment, Lordship. Before that, Lordship, I want to point out, Lordship, the section 24 to only to refresh your Lordship's memory, Lordship. 24(2), Lordship, is two parts, Lordship. 24, one part is on the date of Lordship convening the meeting, no confirmation. It says what is the procedure. And 24(2), Lordship, says the entire modalities, Lordship. And 24(2), Lordship, A speaks of, Lordship, there must be rules that has to be added, which has to be prepared by the state government. That rule is still today, Lordship, that rule is not available with the state government. And the rest part of the rules 24(2), Lordship, speaks of what is the duty of the sub-regional officer. That has been added to. And this practice, Lordship, all the elected members are being unseated in the state, Lordship.
So when this case was decided, after full bench or before full bench?
Lordship, it is Lordship, before full bench, Lordship. Just before full bench.
This is dated?
Dated, Lordship.
29/11/20.
No, 13/10. 13/10.
And the full bench is?
Full bench judgment, Lordship, the 29/11, Lordship.
Requires consideration, madam. Because learned single judge says, we have to see the intent of the rule.
Lordship.
It's not like that. In election law, 1982, Vasu versus Devi Prasad Ghoshal, the Supreme Court said, once election, the law says something, things have to be accomplished only according to that. The equity, literal construction, purposive construction, that will not be available. We heard that way because I happen to be the author of that full bench judgment.
Yes.
Heard. Learned counsel appearing for the appellant. Any entry model you sought for?
Lordship, in fact, Lordship, they are going to unseat me, Lordship. I must, Lordship.
Have you filed any application?
Yes, I filed, Lordship.
Next one.
I have filed.
Why story?
Sorry, Lordship.
Learned counsel appearing for the appellant draws our attention to application in IN number so and so supported by affidavit seeking interim protection. First, he persistent to intervene the construction placed by the full bench of this court on the provisions of section 24 of Gram Panchayat Act.
Gram Panchayat Act, 1964.
To contend that for a motion of confidence, what has been prescribed under the provisions of the said section are to be construed as mandatory. First one, a case is modeled for issuance of notice and also for grant of interim protection. First one, since matter requires deeper examination. First one, next, in the above circumstances, application having been favored. One sentence. Learned AG requested to accept notice for
1 to 5 years.
1 to 5. No private parties.
Yes, Your Lordship.
Notice to the rest. First of all, application having been favored. What is the interim order you have sought?
Yeah, operation of judgment, Lordship.
Impugn judgment and impugn judgment. Order or judgment or order?
Judgment, Lordship.
He stayed till the next date of hearing.
Grateful, Lordship.
Yesterday, similar matter would happen. Yes, which is that matter. Call this matter along with that matter. Call this matter along with WP number, writ appeal number. So, all right. That two cases will go.
Item 11.
But in fact, the elected Sarpanch of a Gram Panchayat, there was a no confidence motion against him, and that is what he challenged before the Honorable Single Judge.
No confidence motion is challenged.
Yes, before the Honorable Single Judge, and while the matter was admitted, there was an interim order that no confidence motion may go on, but there will be no final result without the leave of the court. During pendency of that writ application, the 9 ward members at whose behest the no confidence motion got triggered, they were all disqualified for not attending the Gram Panchayat meeting on successive meetings.
3 meetings.
Yes. And more than 3 meetings. And the entire allegation of those 9 ward members and what Naib Sarpanch was that the Sarpanch had not attended the meeting of the Gram Panchayat right from the day when she assumed the charge. On that basis, no confidence motion was taken. And after the writ application was dismissed, I have come before Lordship. And yes.
If a member does not participate in 3 consecutive, 3 or 2? 3 consecutive meetings, his membership stands forfeited or some order needs to be?
It is disqualified first, then
how section reads?
Then after answer straight away. Disqualification is under section 24 and cancellation under section 26. And our formal order
26.
Yes.
Read the 26.
Yes. Whenever it is alleged that any Sarpanch or Naib Sarpanch or any other member is or has become disqualified, or whenever any such person is himself in doubt whether or not he is or has become so disqualified, such person or any other person, any other member may, and the Sarpanch at the request of the Gram Panchayat shall apply to the collector for a decision on the allegation of doubt. This is subsection 1. And subsection 2, the collector may so motu or on received.
Read again 26.
Again. Whenever
it is alleged.
Yes, that any Sarpanch or Naib Sarpanch or any other member is or has become disqualified, or whenever any such person is himself in doubt whether or not he is or has become so disqualified, such person or any other member may, and the Sarpanch at the request of the Gram Panchayat shall apply to the collector for a decision on the allegation of doubt.
Yes, comes to this section.
Yes.
Interpret that section.
In case of a doubt, it will be referred to.
Doubt is second part.
Second part, the collector may so motu or on receipt of an application under subsection 1 make such inquiry as he considers necessary, and after giving the person whose disqualification is in question an opportunity of being heard, determine whether or not such person is or has become disqualified, and make an order in that behalf which shall be final and conclusive.
So some formal order needs to be
Yes, Master. And here in this case, all those 9 ward members who triggered the no confidence motion have been disqualified and cancelled by order of the collector. And that was
2.
Yes.
And that was during the time when the writ application was pending, my lord.
Writ application did not interdict that. It interdicted only 24 proceedings.
Yes.
Not 26 proceedings.
Not 26. So what I'm saying, my lord, my submission, if your lordship, my lord, these are the people who make allegation against the Sarpanch. That Sarpanch is not attending the office right from the day she assumed the charges of Sarpanch. And lordship, kindly see Annexure 1.
No, we go by your version now.
Yes.
We have no reason to doubt.
Exactly. And she is not attending. And then there was some allegation that the husband of the Sarpanch, but he is creating some mischief for which the Sarpanch is not opening his hard lips. And then the Sarpanch is not doing anything. These are all omnibus millet allegations. And there is no millet document, nothing millet there in the particular resolution as to what are the kind of wrongdoings or millet, what are the things she has committed against law or against the very interest of the Gram Panchayat.
No.
Not there. And then
Not like that.
why am I saying, Milad?
24.
That is the purpose of saying, Milad. Here, this is something little bit, Milad, I think, with due respect, Milad, little bit, Milad, away from the normal, Milad, situation. Why I say, Milad? Because those 9 people who triggered the entire motion, those 9 people were ultimately found to be, Milad, disqualified and cancelled. Now, these 9 people, my lad, they also only triggered the motion, nobody else. That is the reason I said so, my lad. Otherwise, I would not have. The entire thing got emanated from these 9 people. And my lad, what happens? With due respect, I'm just listening to what a lordship, my lord, fell from my lords in the previous case. There is no, it has to be literary construction, no purposive construction, no. But here, lordship will kindly see, when there is an authority, government authority, who has been bestowed with an authority to do something, he is not a post office. But along with everything is not there to be implicit. But there is some explicit. There is something implicit. The sub-collector, just as a post office, cannot just accept that no confidence the resolution and pass it or allow that, and then refer to the collector for ultimately to be published in the notice board for its implementation. So that is the whole case. And that has to have a debate. But when there is a no confidence motion taken, even supposing there is a meeting, that has to have a debate. The debate has to be minuted, recorded. What was the statement of various board members, Naib Sarpanch?
Suppose if they do not open their mouth.
Yes.
And they say,
yes,
no confidence motion is allowed. And they put their signatures.
Yes.
Which law requires for reasoning, debate, etc., which you are now speaking?
That is what I am. That is the reason I am before your lordship. I am just one judgment of Hon'Ble Justice Indrajit Mohanty in case of Dr. Tamotia. There, Justice Mohanty has quoted something, Milad. Of course, not, but just not come to me, Milad. That the judgments are unlocked in the breast of the judges. When required, they're locked in the breast of the judges.
No.
And when required to be unlocked, Milad.
But firstly, you are not brought that judgment, and therefore we cannot vouch whether such a contention is.
No, that was what on this context that was not said, Milad. What I'm saying, Lordship Milad, arguing Milad, but everything, Milad, is not either Milad explicit.
Yes.
Now, Lordship, see section.
Now 24.
24. Yes.
Let us see whether 24
yes
admits your arguments.
Exactly, Milad.
By text or context,
yes,
or by contours.
Correct, Milad.
Correct. My impression is there is one best book on law of election by Erskine May of England. He treats it, that is called English parliamentary practice. There he has said, once no confidence motion is passed, its validity should be adjudged strictly in the teeth of the law. If we go by that, where is the scope for your contention that there should be debate on the floor of the house, that Gram Panchayat?
But then
They need not to be.
then then
It's a democratic process.
then it is the ipsedixy of few people which will ultimately prevail.
Law is like that.
No, that is the reason I say,
No.
everything is locked inside the best of the honorable judges.
This will
They have to
not
unlock
apply
it.
election law. We have held
Yes.
the proceedings under 24 are a part of law of election. We have held that way. You show that there should be debate when a no confidence motion is introduced.
Not section 24 made it.
Yes, great.
Where at a meeting of the Gram Panchayat, specially convened
Yes.
by the subdivisional officer in that behalf, a resolution is passed supported by a majority of not less than 2/3 of the total membership of the Gram Panchayat regarding one confidence.
In the sarpanch or nice sarpanch. Assume like this now.
Yes.
They say the sarpanch does not conduct puja to sun god. Therefore, we pass this resolution. Can it be examined by the court?
But now my answer to your lordship's query is, when specially convened by the subdivisional officer, what is the I put to myself? Then what is the purpose of convening a meeting? Meeting is just not to have people sit together and cast their vote.
No, only that much. There is a judicial opinion contrary to your submission.
Well, what I'm saying, today we're in 2026, I fall back upon that 1986 Supreme Court 1576, the Bajunath case, what is spelled out in paragraph 90, that the judges have to keep their thinking caps open. It has to match the fashion of the day.
That's all right.
So what I'm saying, what was decided there way back, if the same principle does apply today.
See, sir, the law relating to no confidence motion is not a new thing to us.
But I totally agree.
Throughout, in parliament, in state legislatures, in other popular bodies like local bodies, etc. Not even one judgment there is which says the debate has to take place on the no confidence motion.
My answer is, this is a peculiar case where the 9 people who triggered that, and they have been disqualified. That is the only reason, otherwise I would not have.
No, once we late, so what you want to say? There are 2 things.
Yes.
The fact matrix that would fit into 26
Yes.
can be the fact matrix for attracting 24.
Well, it could have been, if at all, 26 had preceded 24.
No, not like that. Some print has to happen in a particular order. 26 parliamentary practice, in a particular parliamentary practice, which Subhas Kashyap has edited, that is by we have parliamentary practice on par with Erskine May. We have one book, very thick book, Shakdar's Parliamentary Practice, which Subhash C. Kashyap, the Secretary to the Parliament, has edited it, next editions. It's there.
Mr. Kashyap,
If I say there, it is there.
Yes, I
Yes. See, no way I find a support for the contention that 24 like procedure, there has to be debate on the floor of the Gram Panchayat. There need not be, because 24 is, it enacts a democratic process. It enacts a democratic process. If I vote for X, I need not give reason as to why I am voting for X. And why not to the candidate, other candidates in the play?
Exactly.
Criminal.
Exactly. I am not on that as to why I am voting for X, not voting for Y. Or voting for X, why not against X. But there I totally agree with your lordship.
That is
the entire thing, what ultimately gave rise to a filing of a no confidence motion. What is the that particular resolution? Lordship, Annex 1.
Please articulate your first contention.
My first contention is that the no confidence motion got triggered by the ward members who have been subsequently disqualified, and they have been cancelled under Section 26.
When the no confidence motion was passed?
17th February.
17 February.
Yes.
25. 17 to 25. So this is under 24.
Yes.
For challenging this before the learned single judge.
Yes.
What are the grounds you had taken?
The grounds that were
First ground is?
well, first ground in Article 15 of the Constitution, she being a lady. And that particular aspect of have been considered thoroughly, because
She being a lady?
Yes.
What? How gender is relevant?
well, that's not of the ground.
Leave it. It will not help you.
Yes.
Yes, next point.
But next point is, that with regard to this, there was, with regard to the allegation, in Annex 1. It's on omnibus statements. Omnibus statements, and political vendetta.
You mean to say
The proposal.
under 24(2), it's a proposal.
Yes,
You mean to say the contents of the proposal should be proved?
that has to be some material.
No.
That was the ground taken.
So number 2, first one is 15(3).
Yes.
First ground, 15(3). It is. It does not arise to say the least. Next paragraph. Next ground. The allegations in the proposal do not have a grain of truth. And therefore, the no confidence resolution is liable to be set at naught. Then other ground.
Then at the time of hearing of the application, by the time the case matured for hearing, the disqualification was there.
Post resolution, come on. 9 of 13 members.
9 members, of 13 members.
13 members who participated in the no confidence motion came to be disqualified under section 26. And therefore resolution needs to be set at naught.
And not only participated, but also it got triggered from them also.
Who triggered no confidence motion and who participated in the same motion came to be removed under section 26. Any other group?
This report.
Only two. Anything you want to say?
I am on caveat.
Yes.
It's my first submission is that the writ appeal is not maintainable. If your lordship sees the impugned judgment, the judgment was passed in 2 writ petitions. An appeal has been filed in only against 1 writ petition. Now, on merit, your lordship may kindly have subsection 3 of section 26.
Subsection 3.
Yes, ma'am. Lordships read 1 and 2. Your lordship may read 3. May I read, my lords? Yes. May I read, my lords? Where the collector decides that the sarpanch, naib sarpanch, or any other member is or has become disqualified, such decision shall be forthwith published by him on his notice board, and with effect from the date of such publication, the sarpanch, naib sarpanch, or such other member
Vacated the office.
Yes, ma'am.
Oh.
So therefore, it is prospective in nature. I have been declared disqualified on 4th of December, which is even after the judgment. The impugned judgment is on 29th of November, and I have been declared disqualified on 4th of December. My actions on 17th of February remain valid.
No. Karnataka High Court has reversed this view. Justice Shivraj Patil's judgment. Not correct.
And your lordship may kindly have the list of dates. For a moment, your lordship may have the list of dates of the petitioner itself.
No, in fact, we are not interfering.
Very well. Just the other point also, he says that I have not attended, my learned senior says that I have not attended on 3 dates. Those 3 dates are 7th January, 26th February, and 19th March. So on 17th February, I had not even incurred disqualification.
as on the date resolution was passed.
Yes, ma'am. Beautiful. And only one more part, for
Yes,
that.
yes, sir.
Now, sometimes the law may seem that 2 plus 2 is equal to 4, but the justice demands 2 into 2 is equal to 4. So what I somebody law has to bend before justice, and here justice has to be seen to have been to be done. But that is what the Nagaraj state of Karnataka, the judgment of Honorable Justice Reddy, Honorable Justice Jivan Reddy Balad.
VP Jivan Reddy.
Yes.
They are a case relating to employment.
Yes.
Reservation and employment.
I'm just reading 4 lines. Justice is a virtue which transcends all barriers. Neither the rules of procedure nor technicalities of law can stand in its way. The order of the court should not be prejudicial to anyone. Rule of stare decisis is adhered for consistency, but it is not as inflexible in administrative law in the public law. Even law bends before the justice.
That is also the judgment of our own High Court.
Now, it all emanates from this one.
When resolution came to be passed on?
17th February 2025.
17/2.
Yes,
25. And notified on 4/12/25.
Yes, disqualification.
Qualification.
The order has been passed on 4th of December.
Just give me the dates when I give dictation.
Yes.
Kindly be seated. This intra-court appeal by a removed Sarpanch or Naib Sarpanch? Removed Lady Sarpanch calls in question a learned single judge's order of this court dated, whereby the writ petition number so and so filed by her laying a challenge to the resolution allowing the no confidence motion on so and so was passed. First one. Next paragraph. Learned senior advocate appearing for the appellant writ petitioner vehemently urged the following points for consideration. A. The resolution in question was passed under section 24 of the Gram Panchayat Act so and so, removing his client from the office of Sarpanch, being non-speaking, and while the allegations made in the proposal resolution not having been prima facie demonstrated, learned single judge erred in declining to quash the no confidence motion resolution. First one. B. Sarpanch, appellant Sarpanch being a lady, the provisions of Article 15(3) how do you structure that contention? 15(3) contention you took up.
In fact, there has to be certain violence to be given to the ladies' ballad. As far as the office of Sama.
Women have to be given special protection.
Yes.
Like
and this is also reserved also. This is also reserved. post.
In as much as the post in question, the office in question is earmarked for women.
Well,
Is it so?
Yes.
Is it earmarked for
Reserve.
Yes, yes.
earmarked for women by way of reservation? Reservation. You want to say, Yatra Naryastu Pujjante Tatra Ramante Devataha. But our constitution does not enact Manusmruti. It does not enact, there is one famous judgment of American court by Justice Oliver Wendell Holmes. When Herbert Spencer's economics was cited, he said, American Constitution does not enact Spencer's economics. And the third contention.
Now this
9 of the 13 members of the Gram Panchayat who had triggered no confidence motion and participated in the meeting, in the special meeting, having been removed under section, having been disqualified under section 26, that would cast a shadow with retrospective effect on the no confidence resolution, and therefore this aspect having not been properly dealt with, the impugned order of the learned single judge is liable to be voided.
25, section 25 2B, disqualification, removal 26. Incurring disqualification, section 25 2B, small b.
Council adds that section 25 2B provides for disqualification.
Yes.
And section 26 prescribes the procedure for removal on that by the collector.
Exactly.
By the collector. Next one. Learned counsel appearing for the private respondents on KVL.
I have not been made a party. I was an intervener in the writ petition which has not been challenged. And my intervention was accepted. It was allowed.
On KVL.
Private, no, appearing for the intervener on KVL, who has not been arrayed as a respondent in this appeal, opposes the appeal, making submission in justification of the impugned order, more particularly drawing the attention of the court to section 24(3) of the Act,
26.
26(3) of the Act, which in effect says that the disqualification would take effect from the date the same is notified by the collector. First of all, he adds that till such a notification is issued, there was no disqualification of these 9 members, and therefore what they did in fructifying the no confidence motion would not affect the otherwise validity of such a resolution. That's the first step.
Yes.
Next one. Having heard learned counsel for the parties and having perused the petition appeal papers, we decline indulgence in the indulgence, broadly agreeing with the reasoning of the learned single judge. First one. And we add the following additional points. A. The vehement submission of learned senior advocate appearing for the appellant removed Sarpanch, that the proposal and the resolution of removal disqualification had wild allegations against the appellant and therefore, unless they are prima facie demonstrated, howsoever least it may be, the resolution is not sustainable, is very difficult to countenance. First off, Section 24 enacts a democratic procedure for removal of elected sarpanch. First off, it prescribes a specific procedure. Which aspect has been elaborately discussed by the full bench of this court in so and so. Take out that. First, where an elected member is removed by a democratic process, the question of demonstrating the grounds on which removal has taken place is alien to the scheme of Section 24. First off, in other words, while passing the resolution on no confidence basis, there need not be a debate that would otherwise or normally takes place on the floor of house or the Gram Panchayat, as the case may be. First off, even if no reason is assigned in resolutions of the kind, on that ground, resolution cannot be set at naught as non-speaking. One. First off. Further, on whatever ground the majority of the Grama Panchayat, majority of the members of the Grama Panchayat decide to remove a sarpanch or a naib sarpanch, the court cannot examine whether such grounds are true or not. First one, an argument to the contrary cannot be sustained without straining the language of Section 24. First one, if the legislature intended what learned senior advocate argued, it would have enacted the provision in a different way, which it has not. First off. Next paragraph. The second contention of learned senior advocate that women enjoy special protection under Article 15(3), and therefore, in the case of a reserved constituency, stroke office, the process of removal has to be bit stricter, and that should be read into Section 24 of the Act, is liable to be rejected, to say the least. First up, Article 15(3) of the Constitution is a provision which ordinarily provides for certain special benefits like reservation, etc., for women and children. First up, this aspect of the matter has been discussed by the Apex Court in a category of decisions. First up, we fail to see how that would be relevant while passing the resolution for removing a sarpanch a woman sarpanch in terms of section 24. First off, there is absolutely no nexus between Article 15(3) jurisprudence and the removal by way of no confidence motion as enacted in section 24. First off, much is not necessary to specify. Next paragraph. The last contention of learned senior advocate that 9 of the 13 sarpanches who had triggered and fructified the no confidence motion out of 13, not 9 of 14, having been disqualified in terms of section 25 read with section 26, that would cast infirmity on the impugned no confidence resolution is again difficult to agree with. Firstly, it is a subsequent act. Law as enacted in section 24 does not recognize a subsequent act as invalidating the resolutions passed for removal of the incumbents of the office of sarpanch. The full bench in the case Supra has held that Section 24 enacts a piece of law of election, and the law of election is what the statute in so many words says it to be. Therefore, in adjudging validity of no confidence resolution, one cannot travel beyond the contours of section 24, and the contention now taken up would not fit into even the penumbra of the said provision. Added, these 9 disqualified members continue to be in office till 4/12/2025. That is that under subsection 3 of section 26 of the Act. Thus, there is no connect between the resolution in question and their subsequent removal by the collector because of disqualification. In the above circumstances, the appeal being thoroughly meritless is liable to be rejected, and accordingly it is, courts having been reluctantly made easy. Yes. Next. We'll revert within a crucible of minutes. Have you shown it to 6 minutes? Item 8.
This is the instruction submitted by respondent number 4, where the petitioner was posted to the respondent number 3, who is the director. In it, if the Honorable Court...
Not available at the Kevensher for providing proper treatment.
Next page is... Thereafter, in second page, Office of the Chief District Medical and Public Health Officer Cuttack has written to the respondent number 3. The Standing Medical Board examined him along with treatment records and opined that this is a so-and-so disease and the rheumatologic and the immunology department is not at Kevensher for proper treatment. I am enclosing herewith the proceedings of the Standing Medical Board on dated 3/11/25 in favor of Pulin Kumar Das, who is the appellant, for your reference. Next page is the clincher, mallards, that the appellant went and approached at the medical examination. Third page.
You appear. What is the report?
Well, is that no medical facility is there at Kevensher as an outcome which I cannot be treated.
Where is that report?
Well, it's the report. I wasn't given with the report. Only this letter, these 2 letters were given to me with substantiations.
Madam, you procure report tomorrow?
Yes, Your Lordship.
You procure report tomorrow.
Tomorrow, Your Lordship, on Monday.
Tuesday.
Monday.
Tuesday. Call on Tuesday. Great. Any document you want to file in the court, it will be by a memo.
Yes.
Sorry. Item 12.
Grateful. Item 12, may I please, Your Lordship?
Yeah.
Item 12 is the appellant in the capacity of Sarpanch, Your Lordship, has been disqualified under section 25(1)(v) of the Odisha Gram Panchayat Act. 25(1)(v) is where he has more than 2 children on or above the cutoff date. And 11(b) is qualification where he is unable to read or write the local language Odia.
Which is the section which they have invoked in your case?
Both, Your Lordship.
Both.
In the lower
court.
court.
Know how to read, write.
So we can actually. We can. It is the 4th time we have been Sarpanch. How come I was elected, sir, 3 times before if I have not fulfilled the categories? I have already qualified. I have studied. There is no specific
about the children.
The children also, Your Lordship. I have marked the paragraph from the lower courts, from the appeal, from the learned single judges till today. I have marked the entire paragraph. I have relied on 14 documents in response to their only one document that they had relied from an RTO.
The question is,
yes, Your Lordship.
Have you 2 children, more than 2 children or not?
We have more, yes, yes, Lordship, but before cutoff date, sir. My last child was born on 6/11/1994.
Let us see the
yes, sir.
section.
Section of the?
Which section is which 25?
25(1)(v) is for the children.
25(1)(b).
1(v), sir.
Just read.
Yes.
The objective, see, we have population explosion like thing today. So we are reaching what Malthus has said 400 years ago. The population, eating the population itself and the society withering away. See, what is the extent of our population now? Population growth rate is very high.
The highest in the world now, sir.
We have crossed China. And the land mass remains same. Resources remain same. Okay. So this will be dangerous to the sustenance of the constitution. Our constitution, then we say just a particular population. If it exceeds, it will alter the substratum of the constitution itself. That is the reason why Apex Court upheld validity of similar provision in a particular case. I don't remember that which state law, Haryana perhaps it appears to be. Haryana, Himachal Pradesh, something like that. That is the intent of this provision. Because in 3 judgments, Apex Court said the measures have to be taken for reducing the population growth. Otherwise, country will collapse. And nobody is bothered. Yes, read on.
In the section, your lordship, disqualification for membership of Gram Panchayat. A person shall be disqualified for being elected or nominated as a sarpanch or any other member of the Gram Panchayat constituted under this act if he has more than 2 children.
More than 2 children.
Lordship.
On which date this section came into force?
Lordship, this is their
original section?
1964, your lordship.
1964. When did you have 3 children?
Lordship, 4 children.
4?
Yes, sir. But in 1994. But the cutoff was on 5th April 1995.
Huh?
The fourth child was born on 6/11/1994.
6/11/1994.
Your lordship. The law came in respect of having children in 1995. 1995. I was born on 1994. This law came in 1995, the cutoff, on or before. It is recorded in the Learned Trial Court judgment also.
The question is not that. As on the date you contested the election,
lordship,
you had 3 children. 4 children.
Before my first election also I had four children. Before my first election.
That makes no sense, sir. Why you were allowed to continue? There only you would have been removed actually. Anyway.
I was removed.
What the learned single judge says?
Learned single judge in the Learned Trial Court, it was confirmed.
All they have said,
I was removed from both the aspects. In the Learned Appellate Court, your lordship, only one aspect was confirmed, the other was set aside. The birthday of mine. The 1994 case was taken into consideration. So, but the other part, 25, the Hindi, the talking in Odia, that part was upheld, due to which I was removed from my post. The confirmation of the Learned Trial Court in election miscase.
No, it says, read the section 25, main provision.
My lord.
A person shall be
disqualified.
A person shall be disqualified.
Yes, sir.
For being elected also, or nominated as a sarpanch or any other member of the Gram Panchayat constituted by the act, if he which subsection? Class?
First is 25, subclass 1, subclass V.
Subclass B.
V. V for violin, volleyball.
V.
The last one.
V. Has more than 2 children.
More than 2 children.
Yes, you have more than 2 children. Over.
Then this cutoff system was not there, your lordship. This provision was not there. Before, I will read it. On 23rd April 1995, the first law related to if a person on or before has this child, he will not be a part of this law. Anyone after 1995, if has more than 2 children, then they will be subject to disqualification. It is cleared from Orissa High Court decision only, your lordship.
Which is that?
So lordship decision suddenly.
That I will be granted. Whoever wants time, we should ask in the initial, after knowing the mind of the court,
No, Your Lordship, that is the truth of the matter. I may seek assistance from some seniors if possible, but the fact of the matter is
We do not know.
on or before.
Fact is what is demonstrated by records to us.
So it is recorded in the judgments of the trial court in respect of.
No, the clause V,
Clause B.
which now you are pressing into service,
Your Lordship.
that V came to be introduced to the act when? It was there originally.
It was there originally, so but the clarification came.
Where is the clarification?
So it's a notification.
Notification is in your pocket. Law is very clear. Under which notification? Under which section? There is nothing like that.
There is, Your Lordship. There is a cutoff date with the exact term we have been using.
Where is the section says like this? It does not provide for any notification being given by altering the cutoff date.
But cutoff date is recorded in the entire judgments regarding any person who is on or before they had 4 children, they will not come under the purview of this 1995 changes.
No.
After 96, for example, this case is regarding that. It has been decided that way only.
No.
That I have been, sir, my lords, I have been trying to convince the learned trial court that I was born before 1995.
That makes no sense.
Sir, that is the current law of the land in respect of.
Show that.
If my lord will grant me some time in respect of this, I will
pass over. On the wasting time of the court, we don't agree. We come with a lot of preparation. We should not waste time of the court. Yes. Item 13, pass over. Item 13?
My lord.
Yes.
In this matter, my lord, the petitioner has challenged the order passed by the CHITTARANJAN under section 14 of the Surface Act.
Please, sir.
CHITTARANJAN.
My brother is expert in surfacing.
Yeah. White, Annexure 1, page 13.
Yes.
Milord,
You are the borrower or guarantor?
Milord, I am the borrower and guarantor. It makes but borrower mortgager. So while the application was filed by the bank before the CHITTARANJAN, there must be 9 points.
9-point affidavit.
Clauses to be demonstrated in that application supported by an affidavit.
But it's an appealable order.
Order is Milord, appealable because one judgment of the Harsh Govardhan judgment has categorically stated, Milord, that in spite of the appeal, statutory appeal is there, but the Reed court can interfere the matter. That is the paragraph.
Only with the innocuous prayer.
Yes.
See that the matter is to be disposed of with an
Yes. Milord, what happened, the CHITTARANJAN posted the matter to 23rd 12/2025, but order was passed on 1st 12/2025. Your Lordship, kindly see page.
You participated in the proceeding?
Yes, my lord. I brought to the notice of the CHITTARANJAN that there is a no 13-4 notice and possession notice has not been complied with.
You challenge before the DRT? Yes.
My lord, but
what is the stage,
with permission, your lordship, give paragraph 22 of the Harsh Govardhan judgment, my lord, that is a subsection 3 of section 14 of the Surface Act provides that no act of the Chief Metropolitan Magistrate or the District Magistrate or any officer authorized by the Chief Metropolitan Magistrate or the District Magistrate done in pursuance of section 14 shall be called in question in any court or before any authority. The Surface Act therefore attaches finality to the decision of the Chief Metropolitan Magistrate or the District Magistrate, and this decision cannot be challenged before any court or authority. But this court has repeatedly held that statutory provisions attaching finality to the decision of an authority, excluding the power of any other authority or court to examine such a decision, will not be a bar for the High Court or this court to exercise jurisdiction vested
by the Constitution, because a statutory provision cannot take away a power vested by the Constitution. To quote the observation of this court in Columbia Sportswear Company versus Director of this my respectful submission. No, auction has not been commenced.
They are going for possession, you are saying?
Yes, case was going to 23rd, 12, 2025, but CGM passed the order on the first 12, 2025.
What was the application before CGM?
Before this
Section 14.
Under section 14.
What is that?
That is application.
Possession.
Possession.
Yes.
Here.
Before auction or after auction?
Before auction. Also, that application
to take the possession.
Yes.
Yes.
My lord, here, my lord, here, before the CGM also, in which manner the bank has filed the application, the statutory provisions has not been complied with. Your lordship kindly see, the CGM himself passed that a specific order. Your lordship kindly see page number 26.
So what will be the consequence?
This matter because interpret and matter remanded to the CGM to pass in because those are
the amount. What is the amount?
3 crores 58 lakhs expected demand notice.
3 crore 60,000.
All right, you deposit 50% of the amount, then we will entertain your petition, not otherwise.
Yes, my lord. Yes. 50%, my lord.
50% of the amount you deposit in the bank will stay rest of the things.
My lord, 2 weeks time. 2 weeks.
2 weeks. Issue.
I'm appearing for the.
You take that money first, whatever money is coming. Money is my God, and how to get it is my religion. Take that money, you are for the bank. You take that money, let him deposit. Otherwise, we can dismiss the petition itself. All right.
I will solve the copy if it requires.
Yeah. Challenge is to the order made by the magistrate under section 14 of the Surface Act 2002. First one, learned counsel for the opponent or petitioner. Petitioner submits that the 9 points affidavit in terms of 14.2 has not been filed, and the points are not demonstrated, and therefore the order of the magistrate directing possession to be taken by the lender needs to be interfered. First, learned counsel, panel counsel appearing for the bank opposes the petition. Petition. First, at this stage, learned counsel for the petitioner agrees with the proposal of this court that 50% of the amount due in terms of the demand notice should be deposited in the bank in 2 equalized weekly installments. The first installment to be the first of the 2 installments to be paid to the bank within 1 week, and the second within 1 week next following, failing which not only interim order of staying the impugned order is stayed, first of, failing which not only interim order stands vacated, but the petition itself runs the risk of dismissal on that ground. Next paragraph. Subject to the above, there shall be stay of order of the impugned order of the magistrate. First, call this matter 1 week will be over when?
Lord, with permission, instead of 2 weeks, let it be 4 weeks, 2 weeks.
2 weeks. And next 4 weeks. After 2 weeks, which will be the date?
Yes.
So, after 2 weeks, 30. Call on 30 January. On 30 January, first installment is not paid.
Yes, definitely.
Yes.
Mobilized, demobilized.
No.
Item 14.
Yes, the second patient
Yes.
Let's see the petitioner challenges the illegal and arbitrary and exclusive imposition of penal charges.
14. Serial number?
14.
14. Yes.
Let's see the petitioner taken a house loan, construction of their house, taken a loan amount. Let's see.
What is the amount due?
Let's see, taken 48 lakh.
What is the amount due as on this date?
Let's say I have already 33 lakh already paid.
You are not. Our question is how much you repay. Our question is what is the amount due as on this date? You appear for the bank. Okay. What is the amount due?
I don't know what it is.
Yes.
Let's see, I have taken 48 lakh and 33 lakh already paid.
Today, what is the amount due?
Let's see, cost has been imposed 11 lakh 5 penal has been imposed this thing.
So the principal amount has already been paid. You are only on penal.
Penal, so let's say principal amount to 33 lakh payment comes. Let's see.
33. When it was taken?
Let's see.
That amount was borrowed when?
Let's see, in the year of 2015, I have taken 48 lakh.
48 lakhs?
Let's see.
That is 10 years ago.
Let's see. I have already paid 33 lakh.
By the time the auction notice was published, you were due with 63 lakhs 15,772.
You deposit 50% of the amount. Now what has happened? Whether there is the order under 14.
Let's see.
For taking possession.
Let's see.
Huh?
Let's see.
Then same order. We will print the same order. You will show your bona fide.
Let's see.
Okay?
Let's see.
Print same order.
Let's see, a small prayer before the Senate court. Let's see, 11 lakh has been penal due to
We'll consider that. We'll consider that now whatever amount is due.
Let's see.
That demand notice is there, na?
Let's see.
That is in terms of demand notice that you have to write. Demand
Sell notice. Auction sell notice.
Auction sale notice.
Let's see.
Stay of scheduled auction subject to complying with other above conditions. Our auction will go on but shall not be confirmed. Like you said, auction, scheduled auction to go on, but the same shall not be confirmed without leave of the court.
Deposit within?
Yes, 2 weeks, 50% 2 weeks, 25% in 2 weeks, another 25 in next 2 weeks. Exactly. Then 50% that about demands in 2 equalized fortnightly installments. Telling this, not only petition stands rejected, interim order stands vacated, but petition also runs the risk of dismissal.
Copy made.
Huh?
Inputs are copy made.
Yeah, we give full copy. Well, yes, yes.
May I clarify that point again? We'll read the section. In the same section, it is there in the below paragraph, Your Lordship. The person shall be disqualified for being elected or nominated as a sarpanch or any other member of the Gram Panchayat constituted under this act if he has more than 2 children. Below paragraph provided, Your Lordship. I'm sorry, I didn't put tick over here.
Section
25.
25 1B again.
1B.
Then provided is there below. This is the Gram Panchayat Amendment Act, Your Lordship, of 1994. Provided that the disqualification under clause 5 shall not apply to any person who has more than 2 children on the date of commencement of the Amendment Act 94, or as the case within a period of 1 year of such commencement, unless he begets an additional child after the said 1 year.
How learned single judge has interpreted that?
Learned single judge has interpreted relying upon the learned trial court's order and the confirmation part, I have also marked the relevant paragraph in the trial court, page 58, page 51 of the brief. Page 51 of the brief, where
your fourth child was born in 1996.
No, Your Lordship. 96 is the contentions raised by the losing candidate who was number 2. The present respondent is the losing candidate number 2. He was against me in the election.
They are asking a question.
Your Lordship.
When your third child was born?
I was born on 1994, 25/11/1994.
Why you say I was born?
My son. The appellant's son.
Appellant's son. Third son is born on?
Fourth son is 6/11/1994. The last.
Third.
Third was 93, 92.
Tell the date.
Date, third child.
Provided that the disqualification of the clause B shall not apply to any person who has given two children from the date of commencement of the proceedings, or, as the case may be, within a period of 1 year of such commencement.
Third son is 11/3/1993. It is in the record.
11/3/1993. Then your clause proviso will not apply to you at all. Proviso will not come to your rescue.
Rajiv Jena, 6/11/1994.
Your 11/3/93 is third child.
93 is the third child. That time, 94.
Fourth son is
6/11/1994.
6/11/1994. That makes your case still worse. Third son is born on 11/3/1993. Therefore, even you will not fit into the protective proviso. This provision came into force when? The proviso.
The proviso came in, sir, 1994, April.
18/4/1994.
18/4/1994.
But already 11/3/93 you had 3 children. 11/3/93 you had already 3 children. Yes, even according to you.
That is the fact of the case.
Then there is nothing. Appellant's membership of Gram Panchayat in question having been terminated in terms of he having more than 2 children, as provided under section 25 into brackets 1 into another set of brackets V, comma, his challenge to the same came to be negative by the orders of the court below, which would include the order of learned single judge. First of all, next paragraph. Learned counsel for the petitioner vehemently argues that he gets protection under the proviso to clause V of subsection 1 of section 25, and therefore his disqualification is unsustainable. First answer. Next person. having heard learned counsel for the appellant and having perused the appeal papers, we decline indulgence in the matter in as much as the appellant admittedly had begotten third child on 11/3/1993, the fourth one having been born on, fourth was born when?
6/11/94.
6/11/1994. First off, learned single judge has construed the provisions of said section in the light of the fact matrix pleaded and also the one demonstrated from record. First off, the proviso which is heavily banked upon by the learned counsel for the appellant reads as under. Next paragraph is quote that. All right. Proviso, yellow marker is vanishing ink, it is page 57 of the book. Okay. You put entire 25 1 V proviso. Next one. The proviso protects an elected member only if he had no third child. As on the date the said proviso came to be introduced to the statute book, that is, date is, which date, brother? You said 1995. Which is the date when the proviso came into force?
18/4 or 1994.
18/4/1994. First off, obviously, case of the appellant is miles away from the protective proviso. He having begotten the third child on 11/3/1993 and the fourth on 6/11/1994. First off, the finding recorded by the learned single judge and by the court below in this regard is unassailable. And there is no reason whatsoever for meddling with the same at our hands. First, in the above circumstances, appeal being devoid of merits is liable to be and accordingly rejected in limine.
Objection.
We are not showing your name. In limine. Yes. Yes, next. Yes. Rejected. Not dismissal. Yes.
Hello. Item 15. Item 15.
May I be your judge?
Yes.
Hearing this, my lord, the innocuous fair is there. The direction to the opinion number 1 to consider the representation of head annexer 5 at page 22 with a view to settle the matter one-time settlement. For that purpose, I made a representation to the opinion number 1, my lord. So fact of the case is like that, my lord. Keeping in view annexer 1, I applied for the loan, housing loan, my lord.
What was the amount of loan?
Loan is 27 lakhs.
As on which date?
That is 18/3/2017. 27 lakhs 85,000, which is reflected in page 9, serial number 2.
What is the rate of interest?
Rate of interest, current 14.20 at serial number 3.
14.20.
Much obliged to that extent.
So that will come to, as on this date, how much?
That so far as with Ross's permission to that extent, that so far the 7/12/2021, it comes to 27 lakhs.
15/1/2026. What is the amount? How much you have paid back now?
So on 18/3/27, 2017.
No. This amount, 18/3/2017, you have borrowed 27 lakh.
Yes, madam.
All right.
Yes, madam. I have
now more than 6.5 years have lapsed.
Yes, madam. 5,33,187.
Huh?
5,33,187 I have paid. Which will reflect
only 5. Which 5 lakh?
Yes, my lord.
Only 5 lakh you have paid.
I have paid on 25/1/2020.
Yes. That means you have paid out of 27 lakhs,
Yes.
only 5 lakhs.
Yes, my lord.
So you have 20 lakhs in the principal.
Much obliged.
Besides the interest.
No, 22 lakhs.
22 lakhs besides the.
Yes, but 22 lakhs.
Yes.
Correct, my lord. To that extent, I made a representation to the authorities, that is OP number 1, with a view to settle the matter on time as per the decision taken by the OP number 1. For that reason, I made a representation by an extra 5.
No, in similar matters, we have dismissed. At the most, if you withdraw, we will say the bank to consider you are entitled to approach the bank. We do not enter. We are not signatory with your own documents.
No, with your lordship's permission to that extent, unless some direction will ever be given to consider my representation, that they may not consider. For that reason, with your lordship's manner.
Deposit 50% here, we will direct them to consider.
Some time may be given, my lord.
I will issue emergent notice. Who appeared?
Nobody has appeared yet. Because of the fresh matter to that extent.
The DG is requested to accept notice for OP number 4. Issue emergent notice to 123. Returnable within 1 week. Now this matter next week. Let us see. Next week, you take steps immediately. Steps to be taken before sunset of the day. Yeah.
I confirm.
Nothing more.
Much obliged.
Next. Yes. I'll come back.
Because on the first time when it was called my lord, I did not remain
not vocal. Be vocal. See how we our voice
during pastoral my lord, I could not attend.
Come to find.
Challenging the order passed by the learned Hon'Ble Single Judge my lord in Annexure 12.
What it says?
It says my lord that not Annexure 12. That is this
is the order of the government.
No, man. That is Annexure 12, not it's 18.
37.
That is 18, my lord. Annexure 18 rejected my claim for regularization from service. That is starts from 141. Only on the ground that my employment was under outsourcing basis. Only on the assumption that my employment was under outsourcing basis. But it is not. From the record, I will show your lordship that my appointment was under contractual basis. And after serving as a contractual under contractual basis, I made a representation for regulation of my service, my lord. Thereafter, my lord, the representation was not considered. That was kept pending. So I approached with the lordship, my lord. And your lordship is
where is your material to show that yours was a contractual appointment?
Yes, ma'am. Yes, ma'am. That Annexure 2, Annexure 4, your lordship, Annexure 3 first, page 83.
This is walk-in interview.
Yes, ma'am. There was an advertisement, and the committee formed by the government of Orissa, they have interviewed, and the persons, those who have faced the interview, amongst them, I came successful, and I was given appointment. Annexure 4 is the offer of engagement, my lord.
Yes, brother.
This aspect is forgotten by the learned single judge.
But that has taken into consideration, my lord.
No, how can the learned single judge say it is outsourcing? A contractual appointment in terms of state resolution 2008, 2012, 2014 is treated not as a outsourcing, not as outsourcing. Because once he is appointed, he gets right to regularization after putting in a particular years of service. The requires consideration. Admit. Issue notice. Learned AG has requested for notice for
All respondents.
Post of 8 weeks. Yeah.
Item to next they have already disengaged the move from my service matter.
Let us see.
Let us see.
When it comes to that.
Fix a date matter because I am
8 weeks as we have said.
Problem.
Item 4.
Your Lordship, item number 4, my apologies, I was not present at the time of call during the process.
Now you are present.
Lordship, my learned senior is, Your Lordship, is on accommodation. So if you want to, I have objection to that.
Please appellate.
My time also, because on the earlier 4 occasions, time was.
Any intermodal is passed.
Intermodal is not.
Then you have no voice.
But what I humbly submit
that's we have not yet issued notice only.
The Honorable Sir. Yes, my lord. I have filed an caveat, but the caveat is not on record, my lord.
Let us see. Call week after next.
Your Lordship, next week can you date?
Next week it is fully boarded, complete exhaustive.
Week after, Your Lordship, there is some.
You are seeking time. You can't put the construction to your constraint to the judges. Yes, my week after next. That's the request of arguing. Request of arguing counsel for the petition. Yes.
Item 5.
The petitioner, now being the appellant, he is challenging Annexure 3 at page 68, Your Lordship. The claim of the petitioner before the Honorable Single Judge was with regularization as Sikhya Sahayak. At page 68, Your Lordship, that has been turned down by the Honorable Single Judge.
Criminal proceeding was pending.
Yes, Your Lordship.
Pendency is not a ground.
Yes, Your Lordship.
That's a criminal proceeding.
Still pending, Your Lordship.
Yes.
The fact of the case is, Your Lordship, that.
No, that's only one level 5. We will not argue other views at all. It's a report.
My lords.
What do you say? For pendency of a criminal proceeding, what is the offense alleged?
The offense is 59.
Agreement. 59.
59, Your Lordship.
That is outraging the modesty.
No, Your Lordship. No, Your Lordship. At page 50. It is a civil dispute. It is 448, 294, 323, 325, 354, 506, 634
is there.
Yes, Your Lordship. So everything is there.
Yes,
my lords. But it was not incidental to my service. Why I am saying so, Your Lordship, may kindly see the order of bail granted in my favor at page 59. The Honorable Trial Court has held that because there was a count, I have already, this petitioner has filed a case against the informant on the ground of a land dispute, Your Lordship.
Yes, all right.
It is a counter blast.
No, we don't know all that.
My lords, I have enclosed that.
The question is, what is the stage of the proceeding? Whether charges have been framed?
Yes, Your Lordship.
Then after acquittal, you come back and you seek recall.
But Your Lordship, the only predicament is, Your Lordship, that the petitioner is 59 years of age now.
We don't know. Then he should not have created an atmosphere or
I have not, Your Lordship, kindly page.
Charges are framed after hearing you.
That I have taken instructions. But at page 59, Your Lordship.
No, nothing like that.
But the judgment, can I just...
Whose clothes are clean?
But Your Lordship, can I impress Your Lordship on the judgment of this Honorable Court?
Yes.
Yes.
If charges are framed, then you don't have a case.
I have the instructions, sir. I have the positive instruction on that. But the judgment of this Honorable Court.
The appellant to state as to the status of the criminal proceeding in which his client is implicated as an accused. First, call this matter week after next. First, non-furnishing of the requisite information may result into a heavy adverse inference being drawn against the appellant. Yes, next.
But this Honorable Court has already held that it was the outcome of the criminal case.
Item 16.
Item 16, my lord.
Yes.
Reporting that the address is left without instruction, afresh notice is to be sent to the respondent.
Fresh note.
In the correct address.
Correct address.
Yes. Item 17.
With a delay of 363 days.
What is there? On merit, what is there?
Yes, ma'am. If I'll, on merit, I'll place, you'll also can call this matter tomorrow, 5 tomorrow, the copies of the read petition and counter applicant.
Next week at the request of.
So that I can give 2 copies, it will be better.
Item 18.
Worship, item 18, I am appearing on behalf of respondent number 1.
What is your friend?
In item 18, they have to file a reply. If whatever notings are there, counter affidavits also condemnation of delay has not been filed by the respondent number 1. No rejoinder has yet been filed. They have to file the objection to the IA.
How many days delay?
Delay is of 398 days.
So as per the last order, we have not served. Copy has been not served for the continuation of delay.
1,868 days.
No, my lord, 398 days it is.
Only 398 days.
In my petition, my lord, it is written that 398 days delay.
No. In your petition, it is 1868 days.
They have written 1868 days. However, the registry was kind to you. It gave a lot of rebate. It will condone delay.
No, sir, not served the copy also. We have not received the copy.
I'll serve it today.
Well, we got next. In the meanwhile, copy of the petition along with the application and documents to be served on the council representing the office. Yes. Also, office objection to be looked after. Item 19.
Item 19.
Yeah. What is the matter?
19, my lord, it is also for condonation of delay.
Ask the registry to print the number of days delay in the published itself. Why you should turn the pages? How many days delay, Mr. G?
My lord, it is 320 days delay. It is record
free according to
copies.
My petition says, my lord, it is 320 days delay.
What is the explanation for the delay?
Delay is, my lord, it was delayed from.
You appear for OP.
Yes, my lord, my delay petition has not been served upon me. Though petition has been served.
Same order. Okay. Next. Item 20.
Here also, my lord, delay of 110 days.
What is the matter on merit?
My lord, on merit, your lordship have also disposed of so many cases in this matter.
Which is that judgment?
My lord, here, relying on a judgment passed by your lordship, we have disposed of so many cases. Here, my lord, the last date there was an advertisement. According to the advertisement, the last date was fixed. This one registration of Rehabilitation Council of India, it was registered on 17/1/2018. Much prior to that, the last date was gone, my lord. But the Honorable London Single Judge has said that that was not one of the eligibility criteria. That was a letter subsequently issued, so it will not be applicable. But by then, my lord, he has not, at the time of last date, he was not having a registration. That is the sole ground.
Which are other matters? Similar matters came before somebody cited one decision, identical matter.
Yes, that was.
Which was that?
That was the judgment of Justice Mishra.
MP judgment.
No, Mr. Misraj. Sashikant Misraj
No,
judgment.
that judgment, that single judge's judgment, when it is appeal came to be dismissed.
Oh, that I am not verified, my lord.
Respondents.
That is in case of Dilip Kumar Parida versus State of Odisha, and of course.
Dilip Kumar
Parida.
The DB.
My lord. No, single bench.
Oh, I saw one DB judgment. In rest of the cases also you have ignored that date.
Yes. Because they have not completed the register, they produced the registration certificate by the last date of the advertisement. So their candidature was rejected.
The learned single judge says?
The learned single judge says that is not one of the eligibility criteria.
Oh, because you have issued that letter subsequently.
My lord. That is what.
Correct it is. Then where is the wrong in this?
The Honorable Single Judge relied upon that decision of K. Manjushri. I relied upon that admin. K. Manjushri. And that Dilip Parida, what my learned friend is referring, that is also there in the connected matter. And here there is a delay of about 1 year.
Delay is of 110 days. Delay of 110 days.
22.
Page 31, your lordship may kindly have a look. Their lordship have said that guidelines laying down the eligibility of Shiksha Sahayaks provided under clause 6 is as follows. This petitioner is having or 6-1, category 1, the higher secondary plus 2 or its equivalent with at least 50% marks and 2 years diploma in education, in special education.
No G. No case.
So we condone the delay so that
delay will come. In all these matters, same delay.
Same delay, my lord.
There's a batch of one common judgment. Not before the cases.
All the with matters. In all these matters, an application, individual applications supported by affidavit or filed seeking condonation of delay of about 322 days, proved in filing the appeals. First, some plausible explanation has been offered and no objections are filed. Notice was not issued?
No.
Right. First one. Learned counsel on request appearing for the OPs very fairly submits that delay be condoned. And first one. Of the above applications having been favored, delay proved in filing the appeal stands condemned. First one. Dismissed for the following reasons. Agreeing with the reasoning of proposal, the learned figure judge. Next. Item 21.
21, my lord. This is a appeal by the state. There is a delay, but in other cases, my lord has passed the similar order. So far, this job contract employees is concerned under 18(6) of the pension rules.
We have dismissed the writ appeal. The subject matter of this appeal is substantial.
Here, my lord, it was allowed.
It was allowed?
So far, one is work charge, another is of job contract. In job contract, you will not
myself and Saul.
Yes. That has been remanded back on the ground of limitation and to
the matter coming from Supreme Court.
Yes, ma'am. That matter.
This is the work charge.
This is a job contract.
Job contract.
Then work charge was dismissed other day.
If it is job contractor, it is covered by our judgment.
Yes, ma'am. That is the judgment I have handled.
What we have done in that matter?
5.6 not the operating. Right. The shortage period is to be taken into consideration for the purpose of qualifying period of service. 5.5, my lords has given the illustration and there it has been considered. Internal page 14.
So we'll issue notice. It has come for issuing notice now.
Come for orders in fact.
Orders means other side is not served. No.
There is a limitation. It is fresh matter.
So we'll issue whether they are served or first time it has come.
First time.
Yeah, issue emergent notice both on petition and applications. Returnable within 3 weeks. Yes. Item 22.
22 here, my lord, limitation is there for this purpose.
What is this matter on merits? Anything on merits?
Merits, my lord, this is in respect of the regularization of some persons, those who are working under the Jilla Swasthya Samiti. They are attendant cum sweeper. So they are been deployed since 2006, but subsequently advertisement made on 2016. By virtue of the interim order of this Hon'Ble Court, they are continuing.
How long they have been continuing?
More than 18 years.
More than 18 years. Before interim order, how many years of service they have put in?
10 years.
10 years. So even Uma Devi will not come to their.
Yes.
If you are continued beyond 10 years with the order and continued for 10 years without order.
Without order.
This is that case.
This is my exactly that clause 1, 2, and 3.
Yes.
10 years of continuous service, sanction post, and so far this continuance by virtue of the order or
without order.
Without order. Interim order was 2019, my lord.
But by that time they have already put in more than 10 years of service.
13 years.
13 years.
Yes. And it was a schematic appointment under this for 1 year purpose. That was the
appointment, but they continued for 10 years.
DLR continued on DLR basis, and that continued for years together.
Then in one matter we held electricity matter, or what is that? Electricity board matter, where we said if it is beyond 12 years, you should create posts and regularize them in service.
Posts are there.
They are posts there.
Yes.
What the reasoning of the learned single judge?
Because the sanction posts are there, you regularize them.
And without taking the prior approval of the authority, the concerned authority, the CDMO, they have passed this order.
Which authority's permission was required under which law?
Not under this, so far this Group C, Group D employees for regular and appointment are holding in the field Miller 2013, which was subsequently refilled, and in 2002 the new resolution came. Therein, Miller, contractual appointment oblique engagement made against contractual post created with the concurrence of the finance department on abolition of the corresponding regular post or contractual appointments, engagements made against contractual post created with concern of the finance department.
There are posts, vacant posts are there. And they are appointed to those vacancies.
And to that particular period, 44 days, that is a scheme, because it is sometimes it is a central scheme, sometimes it is a state scheme, Rogi Kalyan Samiti, Jilla Swasthya Samiti,
NRHM.
Under the NRHM scheme, And they have never engaged against any sanction post. But admittedly, they are continuing because of the scheme,
So
No, your friend says there were posts and there were vacancies.
Yes. When we continued on a ad hoc basis, while after 10 years, they issued an advertisement to fill up those posts. Against
There were posts.
yes. Against that advertisement, we approached the State Administrative Tribunal. Thereafter, that matter was transferred to this Honorable Court. And Honorable Court, taking into account that advertisement, has held that there are, in that advertisement, they advertised to fill up 66 posts. 62, sorry, by 62
That
posts.
is 62 posts. And this was made in 2016.
Yes.
In fact, OP number 3 had recommended
OP number 3.
regulation of the services of these people.
The CDMO.
Who is OP number 3?
CDMO.
CDMO, he is the appointing authority.
He is the appointing authority. Nothing. There is nothing. It's only to trouble the poor employees. No problem. Delay condoned.
Yes.
Application allowed, delay condoned. Dismissed it agreeing with the reasoning of the Learned Single Judge. More particularly because OP3 had recommended the case of the petitioner, that is the respondent's parents, for regularization. He himself being the competent authority for appointment. But other reasons to follow. Yes.
One prayer. That order, because of the pendings of the return, that order has not.
The petition appellants to implement the order of the Learned Single Judge within an outer limit of 8 weeks. 8 weeks. Without giving room for coercive action like contempt petition. Yes.
Item 23. Item 23.
Yes, I can.
Yeah.
So there are two interim applications. There are two interim applications. One is application for grant of leave to file appeal, and other is.
You are not party.
No. And other is condonation of delay.
You could have gone before the Learned Single Judge only, filing writ petition in view of that, which is that Shivdev Singh versus so and so, 63, 64 Supreme Court.
Oh, 63 Supreme Court 1909.
You have to file writ petition there. Will permit you.
Question is, my lord, definitely he can file a separate writ petition for rehearing the whole issue.
Yes, whole hearing.
But then
because he has already heard. That is the reason. The philosophy of 1963 is judge who has heard has already the facts. Therefore, we need not spend, two judges need not spend time.
I thought I'll be safe before two judges.
you have to face two judges. And you will not have the right of appeal also.
No, I will not require that right of appeal. Your Lordship will understand the point.
We'll give liberty so that it becomes easy. This intra-court appeal seeking leave.
In fact, I'm sorry, I interrupted. We were not necessary parties then. After the judgment is implemented, cause of action for us. That's the point. So
that's right. Then the single writ petition.
That is probably now what 631909. If I would have been a necessary party then.
No, not like that.
Probably that.
Not like that. An aggrieved party. An aggrieved party need not be a necessary party. Because after the event you get aggravation.
Let us, otherwise again I'll have to travel before your Lordship. If I would have been a necessary party then and not implemented as a party, then I'll ask the same bench. Let me
re-examine that 63 Supreme Court.
2 weeks.
Because again, let me not commit the mistake of again approaching your lordship.
Correct. Item 24.
Can it be next week? I'm sorry, Lord.
Next week we have the post it next week.
Grateful.
Item 24.
Delay of 135 days on merit. This is regarding to payment of the UGC scale of pay. Demonstrator, they are working, and as per the UGC circular, and they have implemented it, but partly they have paid. I am eligible to get the scale of pay 8,000 to 13,500, but they have paid me 5,500 to 10,000.
They have paid you in a different pay scale only.
Yes.
Not that pay scale.
Not that scale. As per the UGC circular.
What the learned single judge said?
Single judge said that because I have filed the second writ application and for the implementation of the order, so the writ is not maintainable.
Implementation of which order?
First order.
Yes, but then why you filed writ petition?
Because I have filed also contempt. After contempt, they have implemented partly. That was contempt was dropped.
On part implementation?
Yes. And there is a division bench judgment of the Bombay High Court and Calcutta High Court. For implementation of the order, the
separate writ petition can be
filed. Can be filed.
Under their rules?
No, not writ application. That in view of Article 226. That is the...
Because there is an order under 226. The fruits of the order have not reached your hands. And your contempt petition also did not help you. Then can you file another writ petition for getting the same benefit on the same cause of action?
Because
it is not res judicata.
No, it is because it is not properly, completely implemented. It is partly implemented.
Implementation of order is one thing. Second, litigation on the same fact matters and same cause of action is another. If there is no implementation, you should seek a decree in terms of that order so that you can execute it.
That was my prayer.
But not here. Not here.
No, in the REIT, 2025 REIT, that is also my prayer.
Prayer for?
For fully implement the full-fledged implementation of the order of this Hon'Ble Court.
Correct.
That was my prayer. Because they have partly paid, partly not paid. So because of that, part of that, I filed this fresh writ application.
Okay, res judicata comes in the way.
No, that division bench of Bombay High Court.
So we will pass order and again they will partly implement and again we will file one more writ petition. This we will go on for 1,000 writ petitions.
No.
Then,
because already contempt was closed.
Correct. Closure of contempt. How that is going to give you a fresh cause of action?
Just because they have not fully implemented.
No, probably couldn't understand Lordship. What is then the way out? Even another order will be passed by this court. Again, part implementation. Then what will happen?
Then this writ application.
Again. So that is.
No, this is a fresh cause of action.
No, having considered we are of the view that.
But the fifth line says, further consequential if have been sought for with respect to the fresh cause of notices, including restraining the respondent from taking any steps or acting in furtherance of fresh cause of notices. Not same petition. It cannot be.
Also, the Calcutta High Court also.
No, also, don't say also. It will not come to you. Let us see what Calcutta says. What it says?
It says that for implementation.
For implementation of the judgment,
yes,
you can file a fresh writ petition.
Writ petition. In the first para say this that it is contended by the respondent that they are taking steps in pursuance to the direction passed by this court in the earlier writ petition. So on that ground, the second writ petition filed that.
In para 4, petitioner has relied on the judgment rendered by this court so and so, wherein the petition states that court has held it is a settled law that second writ petition is maintainable for implementation of the earlier order of this court. He further submits that court must issue proper direction for implementation of its previous direction, and that wherever the order has been issued by the bench, the same shall be complied. He further states that an act done in willful disobedience of a court order is not only contempt but also illegal and invalid act. The language in Article 226 of the Constitution of India is couched in comprehensive phraseology, and the said article recognizes a wide power of the High Court to remedy justice wherever it is found. Accordingly accepted and notice was issued. And our Honorable High Court single judge also held that for implementation of the earlier order, the second writ is maintainable. Okay. Single judge of this Honorable Court.
You take notice, please. What was your prayer? What is your prayer here?
Prayer to implement the full-fledged implementation of the order of this Honorable Court.
It is like execution only. Take notice, let us see an important question arises.
Yes. Delay may be condoned.
Without notice?
No, delay 135 days only.
Who
on merit government. Delay of 135.
Issue notice. Learned TGA on request accepts notice for the OP, sole OP. First off, learned counsel for the appellant, petitioner or appellant?
Appellant.
Draws our attention to application in I number client so supported by affidavits wherein a short delay of 100 and odd days is sought to be wherein a prayer for condonation of a short delay of so many days is made. First off, counsel submits that there is a plausible explanation for the delay group and that he has got a very good case on merits. First off, there is some force in this submission. First off, in the above circumstances, application is allowed. Delay is considered. You are accepting notice, no?
Yes, please.
Call up to 6 weeks.
Full respondent.
Item 25.
So item 25, Lord, have entered appearance by filing caveat, Lord, for the respondents.
I am serving copy. He has entered appearance through caveat. And there is a delay of 89 days only.
83.
You condone that?
Yes, Your Lordship. Yes, ref.
First time it is coming up.
First time.
There is a short delay of 83 days grouped in filing the appeal. An application supported by affidavit accompanies the appeal memo, wherein delay is plausibly explained. First off, condonation of delay would not prejudice case of the other side, in as much as matter would be heard on merits. First off, not condoning will oust the petitioner from court, appellant from court, which court exercising writ jurisdiction in appeal would not do. First off. Next, in the above circumstances, application having been favored, delay is condoned. Okay. Call up to 2 weeks.
Item 26.
Yes. Next.
Item 26.
It's a appeal on behalf of the state. This is a 163 days delay,
What is on merits?
It's in respect of the regulation of the pharmacist, pharmacist regulation.
How many years of service they have put in?
They have put in since 2008, 2008, 10/3/2008. In the mobile health unit.
Yes, sir. Was there a continuation of their service by virtue of interim order?
By interim order. Subsequently, while one advertisement is made, they have approached this Hon'Ble Court, wherein this writ application was disposed of with a direction that the made clear that no appointment to the post in question shall be made till decision is taken by the CDMO Kalahandi on the representation of the petitioner. Right. But without considering such representation and disposing of the same, they have passed the order under Annexure 3 for regularization.
That has been settled, not now.
Yes, sir.
Any direction is given to regularize?
No. My Lord, impugned order is at Annexure 7. That is at para 10 million. Against the available vacancy, they may be regularized. Page 32.
CDMO also had recommended.
CDMO has also recommended, without considering the actual aspect and in pursuance to the order of this Hon'Ble Court, to consider their representation and dispose of the same. Without doing so, it has passed the order.
This intra-court appeal by the state and its officials calls in question a learned single judge's order dated 29 October 2024. First, the operative portion of the order reads as under. Like the operative portion. Next paragraph. Learned AGA Mr. Mohanty, appearing for the appellants, vehemently argues that absolutely there was no case for directing regularization of the respondent employees, and that in any event, the advertisement dated
23rd December 2011.
2011 could not have been set aside at all. First one, he draws our attention to the contents of the order in support of his contention. First one, next point. Having heard learned counsel for the party appellants and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the view of the learned single judge. First one. Firstly, the subject advertisement could not have been issued when there was a specific direction in WP number
195 of 2012.
195 of 2012, wherein the direction was given for considering claim of the respondent employees for regularization before going for regular recruitment process. First, admittedly, the representation for regularization did not see the light of the day, and without adverting to the order passed in the earlier round of litigation, the fresh regular recruitment process has been undertaken, which falls foul of the order of this court. First, next paragraph. We also notice that all the respondents have put in long spells of services, and therefore, whatever constraint relatable to state of Karnataka versus Suma Devi is not attractable in this case. First one, it is not the case of petitioners, appellants, that the services of these respondents is unsatisfactory or the like. First, on the converse, the CDMO, while letter dated 1/11/2018, had recommended case of the respondent for regularization against the available vacancies. First, there is nothing on record to discredit the said recommendation. First one. Next paragraph. The impugned order of the learned single judge is well reasoned, and it accords with the regularization jurisprudence from Uma Devi to ML Kesari and Jago
Dharampal,
Uma Devi,
Sripal,
Kesari and Jago. First one. Therefore, there is no scope for interference of this court in the same. First one. In the above circumstances, appeal being unworthy of merit, he is liable to be dismissed both on limitation and on merits. First, application in IN number so and so seeking condonation of delay is formally rejected. Yes.
Item 27.
May I plead the lordship? Here delay of 3 days only, my lord. It is wrong calculation.
What is on merits?
Merits, my lord, here payment of gratuity act involved, my lord. The petitioner was employee of a central cooperative bank, Hon'Ble, my lord. After superannuation, they did not pay me the gratuity. I approached the controlling authority. Controlling allowed my application. The matter was carried in appeal. Appellate could confirm the same. Thereafter, the other side but came to the before the Hon'Ble court. They preferred the petition. The same was allowed. My voice was dismissed. But one observation which was made, which is against the statute, mandatory statute, because payment of gratuity speaks clearly. Even there is many cases, any type of cases, I am supposed to get my gratuity. And only the rider is that section 4(6) of the payment of gratuity act, when there is a moral turpitude, illegal in my workplace, those circumstances, it can be withheld. They can withhold to the extent the liability will be there. They can withhold entire money. Now, what has happened here, Melon? Everything in my favor. The last paragraph, it was observed that the outcome of that vigilance case, subject to result outcome of vigilance case, that will make create problem for me. Problem that, my lord, tomorrow they can initiate procedure, whereas section 13 is very clear of payment of gratuity act. Even any circumstance, it cannot be recovered or withheld. 14 is the rider, we say that same except this statute, no other statute will override the same.
Take notice.
Take
emergent notice.
That is only small part, but that part is against me.
The last part.
Yes, ma'am. That is the only thing.
But without notice.
Yes, ma'am, obviously.
Item 28.
My case, but equal case.
Never that notice.
Yes,
within 4 weeks.
Yes, ma'am. Highly obliged.
My lords, this is appeal by the government. My lords, there is delay of 158 days.
Don't delay, brother.
Yes.
Case of regulation.
Appeal is filed after booking a short delay of 158 days. 58 days. First off, an application accompanied by affidavit is filed seeking its condonation. First, a plausible explanation is furnished as to the circumstances leading to delayed filing of the appeal. First, learned counsel thus, on request appearing for the respondent, in his usual fairness, submits that application be allowed and delay be condoned, so that matter can be heard on merit. First, in the above circumstances, application having been favored, delay is condoned post after 2 weeks.
Case of regulation, madam.
No, let us see. Next.
Item 29.
In the fresh admission.
Fresh admission, please. Yes.
Item 29, my lords, only 7 days delay.
You take notice.
Live expert is there.
28. You appear for respondent.
I'm appearing for the appellant. I'm the appellant.
Appellant.
7 days delay.
28 is government.
My lords, government one.
Only one. There are two
Notice will go to 2, 3 and 4.
Yes. What is the matter on merits?
Your Lordship, the matter arises out of a selection procedure.
You are for OP.
I'm for the appellant, my lords. I have yes, my lords. Appellant.
What is the matter?
Your Lordship, the matter arises out of a recruitment process for the post of reporter in the Odisha Legislative Assembly. And Your Lordship, the appellant did not qualify in the said examination, and the respondent number 3 and 4 had qualified in the examination, but right now the entire selection process has been cancelled. Being aggrieved by that process, the private respondents have filed a writ application in which I was not made a party. I filed my intervention application. That has been rejected.
Who are you?
Because I had appeared in the examination before the entire examination process was cancelled, and I did not qualify in the second test. It is for the post of reporter in the Legislative Assembly.
Take notice.
Yes, Your Lordship.
Issue emergent notice. Retrievable in 3 weeks.
Your Lordship, may I just pray one thing? My lords, the writ petition is pending. It is posted for final disposal on 2nd of February. May I pray any date before that?
Valid. First after 2 weeks. Immediately after service of notice.
Grateful, Lordship.
Next.
Item 30.
You are only on application, rejection of application, you have come in appeal.
Yes, my lords, my intervention application.
It is rejected.
It is rejected.
So you will be out of the court only.
Yes, Your Lordship, and the matter is on 2nd of February.
Item 30.
Delay of only 17 days.
17 days.
17 days. There is a merit. So far merit is concerned, my lord, will also keep it to next week. And there are 2 to 3 constitution bench decisions. 1963 Supreme Court and Arun Kapoor case, Hemchand case, and subsequently one decision. And that Maharashtra, state of Arun Mehta versus state of Maharashtra, where they have said that suspension is a discretion of the management. So court shall not interfere by reinstating him if the suspension is the order pending inquiry. So those decisions are there.
In contemplation of inquiry or a criminal proceeding.
Yes.
Is ordinarily not interfere. In this case, they have interfered.
Yes.
Suspension is set at naught.
That is, my lord, para 7 of the judgment.
On what ground they have set aside? On the ground of competence, they could have done it, no? Absolutely arbitrary.
That is page 14, my lord, para 7. Having heard Lord and Counsel appearing for the parties and considering the submission made and the fact that on self-same issue, a criminal proceeding is pending against the petitioner, with passing of an order in WPC number so and so, it is the view of this court that the order of suspension is required to be revoked and petitioner be allowed.
I'll take notice. Issue emergent notice. Heard. You are for senior panel counsel.
Yes.
Senior panel counsel. So case is made out for issuance of notice. Issue emergent notice. Yes.
Mr. Lord, but I pray that since he has already filed one contempt application, that 30 days period is over. Pray your lordship,
contempt petition is filed now.
But filed and disposed of. By giving direction that if it has not been complied, it will be complied within 30 days. So now 30 days period is over.
It is open to the appellants to move this court by separate application in the event that any coercive action is taken for the implementation of the rules. Yeah, they can speak today.
Item 31.
May please.
Yes.
But can you see last order? When learned have taken time to comply my lord's direction, 1411.
What is this?
This is my lord, the employees of this institution, in this establishment, or High Court. They came, they counting of 5 years service, which is
period of service
for the purpose of RACP, right? That revised assured career progression. And 1411, let me see, man. Now they are denying the said benefit in a peculiar ground to us, whereas the same benefit has been granted to other persons Those who have also given the promotion in the meantime now. I place the paper, let them comply that order. In 1411, they were directed. Thereafter, my lord's order last week.
Nine 126 order.
My lords, in fact, my learned friend is appearing for the High Court install. They have to comply the.
As per the order of the letter dated 29 December 2025, the special officer of the High Court has not yet complied with the said order and not submitted any report to the government in Home Department. So some more time is required so that.
No, he is not carrying it. There is a slew of orders. Not one order. There are many orders which the court itself is not following. If the High Court does not comply with the order, how can we ask other people to comply with our orders?
As for the 14/11/2025 order, this Honorable Court directed the opposite part number 1, the Home Department, to submit the reply mail.
On order dated
14/11/2025.
So in a single cadre, that is deleted now.
My lord, that part of service has not been counted for any purpose. Whereas in case of the ASO, my lord, that has been counted.
My lords, by letter dated 29th December 25, the Home Department has sought for some
To furnish information.
My lords, by order dated 29th December, we have sought for some clarification from the registry, my lords. This is the letter, and they have not given that
information.
They are not furnishing the.
Not furnishing. They are now trying to submit this. Some more time
It
is
is
required.
29th December.
The query made by the government in Home Department.
No, that's all right. But when the government advocate seeks some information, why the registry of the High Court should not give it?
We will submit mine. Some more time is required because the points raised in the said letter, under which provision of law, the such and such copies have to be observed in the post of junior clerk.
That's not it. Whatever information he wants.
Some 2 weeks time may be allowed so that we will supply the same to the government so that your lordship can dispose of this matter.
In terms of SPO of order for the coordinate bench, the panel counsel appearing for the High Court.
Yes,
you appear for the High Court.
Yes.
High Court submits that. He is trying to furnish the requisite information to the learned AGA, Mr. Behra, within an outer limit of 2 weeks.
Yes.
First off, call this matter 1 week thereafter.
Yes.
Item 32.
Okay.
Two cases, my lord. The first one, I'm for the person, Sasibhushan Parida, and my lord senior is for that same person in another connected matter. But this Sasibhushan Parida dead now. Is no more. There's some financial benefit in this particular case. First case was directed to be given to the person who is now dead. Service. LR have come.
Your command record.
Yes, we have given the address. They have not filed the call title. That is technically.
Well, it's substituted, I think.
Substituted.
By order dated.
In 2017 matters.
Yes.
We are disputing of only fresh matters. What should happen to the old matter?
The person is dead now. Only some.
LRs are brought on record.
Yes, now they have.
Second question. My lords, there are two proceedings against the same person. My lords, during disciplinary proceeding, he retired. So it was converted to pension rules. Then, my lords, he was imposed punishment 50% withholding pension for 3 years. So that was carried to tribunal, my lords. Tribunal set aside that order and directed to give the financial benefits and
release full regular pension.
My lords. But in the meantime, another proceeding was also pending.
What happened to that?
That is
in that
second matter.
I'll
okay.
I'll solve.
For who is
Faster, sir. Faster.
There are two disciplinary proceedings against
one person.
One person.
Mine.
Who is now dead.
Yes.
One proceeding was instituted during the tenure of service. Both the cases were in
his life only.
But ended after retirement.
Ended after retirement. One order directing punishment of withholding of 50% of pension that has been set aside by the tribe.
That is
other one is what?
Other one is that in that first the punishment was given. That means also 2/3 of the pension for a particular period to be with them. Then against that, he filed the appeal, filed the petition before the tribunal. Lord and Tribunal quashed it, saying that the inquiry has not been conducted as per rule. Because Rup Singh Nagi case in Supreme Court 2 judgment citing that the documents which have been exhibited, the witnesses have not been examined, and in a mechanical manner it has been concluded. So that is why matter was remitted back for fresh inquiry. The fresh inquiry, what happened? Just the ditto of that inquiry. Just ditto. Your lordship will find inquiry just copied. Then it was challenged. The tribunal also, after that inquiry, a proposed punishment was given to show cause. At this stage, he challenged that inquiry proceeding and that proposed.
There was an order to not to take any coercive action.
I am coming. Then
he is helping you.
I am grateful to him. But in that, tribunal first one order saying that it is all right, correct, and it was also directed unless it is concluded within 9 months, then it will stand fast. However, they prolonged and after that they concluded and the proposed punishment was given. And instead of giving the so cause, he came to the tribunal. Tribunal at the first instance passed the order saying that whatever the contention is made, that is correct. It has not been done as per the order passed earlier. Then said, however, let us take the opinion of the government. Then the government filed one counter affidavit saying why the delay was caused for all these things. Then ultimately tribunal that dismissed the way. Then against that, this writ petition was filed. In this writ petition, the stay order was passed also. So thereafter, there was no occasion to file any so cause to proposed punishment. And now he has died on 4/10/24. All have been substituted. So my humble submission is that if he dies, that some decisions are there, they presume to be innocent. Because now it cannot be proceeded,
So all pension, family pension and other retirement benefit is entitled to.
It is stayed at your instance.
Pardon?
It is stayed at your instance. You got the stay.
That is right, that is right. But now, my lord, supposing, my lord, whatever the, if your lordship hear the matter on the merit,
We are
then
hearing you.
I can apprise your lordship.
We are hearing you now.
All right. Your lordship kindly see, ma'am. Your lordship kindly see that the first order, page 59. My lord, may I pass on a note?
Yes.
I have prepared a note.
Give them. Note yes, notes no. Was a class 1 officer, class 2 officer?
Yes, class 1 officer. He's a class 1 officer. And your lordship's, yes. While he was working as project director DRDA Hon'Ble from the period 31/10/94 to 21/7/97. Then the department proceeding was initiated by the government in J Department under Rule 15 of the OCS CCA rules 1952, serving memorandum along with statement of articles of charges, Annexure 1. Then 1/12/98 suspended, Annexure 2. Then 25/99 written statement of defense was filed. Then 16/10/99 petitioner was reinstated. Then 18/6/2001 additional charges were communicated. Then the inquiry report of the RDC Northern Division, Annexure 6. Order of government in J Department, withholding of 25% of pension and to treat the period of 3 years of suspension from 1/12/98 to.
What were the charges?
Charges, Lord. The first charges, page 17. Your lordship will find page 20, statement of articles of charges.
What is the charge?
Charges are, your lordship will find.
Two charges.
No,
Six charges.
Six charges.
First charge is
744 bags of
7,440
bags of cement were purchased from L&T company, which cost around 8 lakhs at 13,400 and 110
at the rate of
were back without following the procedure prescribed by government of Orissa, collector and chairman DRDA has also not been taken in the above transaction. Sri Parida issued supply order to Mr. Joy Jaguar Small Pipes, Sambalpur, for supply of 1200 numbers of pipes and 900 mm to so and so to all the 8.8 blocks of the district EPM rate contract. The requirement has not been
without sanctioning, without the sanction of the authority concerned.
Overall, that was the allegation. Overall, that was the allegation. Then the government of India instructions, so and so. Then lordship kindly see.
Banana plantation is undertaken in gross violation of the policy. What, whether he consumed the entire cement or what?
For construction of a panchayat house, all these things, that is what they are doing. So another thing is the last page 21, charge number 6. See, Parida purchased the ambassador car and spent an amount of rupees 3,09,900 from the available cash. He had not obtained order of government for incurring expenditure from the available cash. He has made such an expenditure which is authorized by government and thereby acting beyond the power delegated to him.
Where is the route for, how could he buy the car without sanctioning by the higher authority?
My lord, that your lordship kindly see, my lord, that is not the point.
That is the point.
To my
See, 8 lakh odd cement he has bought, and
but my lord, my point
requirement is not assessed. Then,
my lord, he has given this so-called reply. He has given this so-called reply, but while the inquiry is vitiated,
why it is?
That is the point.
Where is the vitiation?
Your lordship kindly see the order. That was challenged, and the order of punishment annexure 7, lordship kindly see page 55. That this one and 55, lordship kindly see page. My lord, page 56, paragraph 11. Therefore, after careful consideration of the charges framed against Parida, statement of defense submitted by him, finding of the inquiry officer, the representation of Sri Parida against the findings of the IO, so-called reply of Sri Parida against the proposed penalty, and the advice of the Orissa Public Service Commission, government have been pleased to impose the
25%.
Yes, then my lord, this was challenged before the tribunal. So, lordship kindly see
what the tribunal did.
Pardon?
What the tribunal did.
That, my lord, page annexure 8, page 59.
Annexure 8, page 59.
Yes, yes. Annexure 8.
Inquiry is untenable.
Had both parties, examination of records indicates that the rules of evidence as laid down by the Honorable Apex Court in the case of Rup Singh Negi versus Punjab National Bank and others, 2009, 1 SCC L&S Labor and Service 398, have not been followed in the case while conducting the inquiry. Even the authors of the documents exhibited have not been examined. In view of the said position, the inquiry report at Annexure 9 is untenable and quashed. Consequently, punishment at Annexure 13 pursuant to the inquiry report is also quashed. The proceeding inquiry is remitted back to the disciplinary authority for appropriate inquiry in tune with the decision of the Honorable Apex Court in the case of Rup Singh Negi, so and so. The inquiry be completed within a period of 9 months from the date of receipt of these orders, failing which the charge will be deemed to have been quashed and all consequential benefits settled in favor of the appellant is accordingly. So, my lord, after that, your lordship kindly. And
this order was not challenged by the state?
No,
not challenged. Here the challenge is second show cause notice.
After notice.
My lord.
After
notice is under challenge.
Report has been submitted.
My lord.
The second show cause notice.
Proposing imposition of penalty was challenged.
What kind of order this is? Heard both sides. Examination of records indicates that the rules of evidence have not been followed.
My lord, very cryptic. But since there was an order to conclude within 9 months, perhaps government didn't.
Unheard of. Even first year law student would not write such order. Something is more than what our eyes are meeting. Now it is at the stage of second show cause notice. After remittance, matter was remitted.
But the point of consideration before your lordships, I would like to apprise. But the first inquiry report was quashed as per this order. If your lordship will compare the next inquiry report, this is the ditto and copy to the first inquiry. No further application. That I'll show to you.
No.
Lordship kindly see the first inquiry report is Annexure 9, page 60.
How many pages first inquiry report is?
60 to 70.
60 to 70.
62
to 70. Not 60.
No, sorry. First inquiry report is page annexure 6, page 46.
47 to 54.
46 to 54. Your Lordship will compare. Your Lordship will find.
Without any tender, 7,440 bags of cement being bought. He thinks that he is a Mughal of Orissa.
No, factual aspects I have not gone through, nor I have applied to my mind, because on the aspect of the proceedings I have gone through to apply the proceedings. If your Lordship will find that inquiry report, this 47, that has been quashed. If your Lordship will find this, your Lordship compare page 60.
See the way he conducts the
Page 60. Lordship, kindly compare, my lord. This is page 47. Then Lordship, charge 1. 7,440 bags of cement at a cost of rupees so and so. It starts with this. Then Lordship, kindly see page 64.
60. No, where is the second report?
Second report I am drawing, your Lordship, page 64. That is begins with page 61 and 62. 62. As against the findings, as against the charges. Charge number 1.
Did you dispute the records produced by the presenting officer?
Before the inquiry officer.
Before the inquiry officer, did you dispute the authenticity of the documents which were produced for proving the charge against you?
That he has replied to that.
Where is that? Reply means what?
He has replied.
No, these records.
No, in the
bank upon are all records.
In the inquiry proceedings, if your Lordship will file the second time, your Lordship kindly see page 63. There is no examination of witnesses.
Examination of witnesses. This is not prosecution. It is a disciplinary inquiry. All records are produced before the inquiry officer. On the basis of, therefore, I am asking you, did you dispute the authenticity of the management records?
Yes, he has disputed in filing that document.
Sentence. This is not 302 for examining all eyewitnesses.
By preponderance of probability, that has to be done, my lord, on the basis of that.
Where have you stated the documents?
My lord, Annexure 10, page 71.
Where have you stated? You have only repeated mantra. The witnesses have not been examined. Witnesses have not been examined in pre-trial.
This is second time. First time I had.
Why witnesses should be examined?
I had also given that, my lord.
Did you dispute? You have to answer that particular question. Did you dispute authenticity of the documents which were marked in evidence to prove the charge against you? This is a disciplinary inquiry.
My lord, I had given in written statement. I had given.
I'm asking a question. You have to answer by drawing our attention to particular paragraph. Otherwise, we are dismissing the petition with heavy costs. What kind of 8,000 odd bags of cements being bought without sanction, and the amount being released to so many beneficiaries in a lump sum. There is no bank account. He is a rank Sukram, whom Supreme Court convicted. Which is the judgment, Sukram versus so and so. That matches this one.
Telecom.
Where have you doubted authenticity of the records? Where have you doubted? You have not said that these records are not from the, they are not official records.
Your Lordship will find from that inquiry report.
No, you have not inquiry report.
You have submitted a
Your reply you have submitted. In that reply, you should have said, whatever documents you have produced, they are not, they are all spurious documents. Therefore, I don't agree with them. That you have not stated.
After getting the memorandum of charge, article of charges, and documents and witnesses, to that I had replied in the written statement.
Yeah, show that.
Of defense.
You are not showing that.
That is Annexure 3, page 32.
You have to show. We are not here to read ignorance. We are not high school students. We are here to exercise our writ jurisdiction, which is limited.
That is right.
Because under 227 it is. You are coming against the order of the tribunal. You have to find out this is the infirmity which is demonstrable record. You can't ask us to read all the 200 pages. We will not be able to decide one single case if that happens.
32. 32, no?
But one sentence.
Lordship, kindly see that. I've given that.
Mr. Mahathir, there he is saying only I deny each article of charge and the request that my written statement of defense may be considered. That's all.
Page 33.
32. You said page
32. Well, the detail is given in 33 page. It starts. Against all charges, he has replied.
We are asking you, in every disciplinary inquiry, the delinquent will deny the charges. It is known to first year law student. Question is, they had given list of the documents. Where have you denied authenticity of these documents so that to prove their authenticity, the witnesses would be examined from the other side? This is not a 302 case.
Well, at page 33, may I draw your Lordship's attention?
Where have you mentioned it?
We will not read that way. You have to satisfy the court if you want our assistance. Otherwise, case goes. Simple.
Another time may be missed.
No time will be connected. You already spent more than half an hour now. You said there is nothing. We are dismissing. Mr. Das, do you want to say anything?
I mean, the past case, but it is their case. And for the same person, I am for the opposite parties. Here in this case, it is there they have to place, then I will answer. If my lord will put me the almost the same question, my lord, to kindly see the order of the tribunal.
You are for whom?
Same person, but different proceeding. The first case, I have succeeded in the tribunal. That they are challenging.
First case, state is the
appellant.
First case, state is the appellant. Second case, the delinquent is the appellant.
The two different proceedings. Different proceedings.
We will concentrate on this proceeding now. On this proceeding. Yes, sir. On this, you have to show. Firstly, doubted. We are again telling you finally that you doubted the authenticity of the document which were pressed into service against you. Where have you stated? These documents are spurious. I have not done anything. You have only denied the charges.
I have denied the charges, but I have explained also.
Justified only. You have tried to justify. You have never disputed the document.
You have denied the charges without disputing the document. And you say the witnesses are not examined. Why witnesses should be examined? Which standard book on disciplinary proceedings would say in all cases witnesses should be examined?
Witnesses documents were exhibited, but the author of the documents were not examined.
Why they should be?
That is those two judgments they have.
No, you did not take up the contention. Don't go to Roop at all. Roop Negi will not come to your help. You have not disputed authenticity of the documents. that were in the hands of a public authority and that were generated in the discharge of public duties. Therefore, there is a presumption under section 32 or 33 of the Evidence Act, which say the documents coming from the proper custody in the discharge of the official duty, generated in the discharge of the official duty, 32, 35.
Kindly say page,
valid document.
page 37.
37.
Next to be exercised. The statement of account for the year 96-97 duly audited by the chartered accountant have been obtained and sanctioned. The utilization certificate and audit inspection report for the prescribed year in respect of panchayats in the district have been obtained and duly scrutinized. It has been ensured that the physical and financial performances under ES has been according to this requirement as prescribed in the guidelines issued by the Government of India, State Government, xerox copy of which enclosed for reference. The above fact has also been accepted by Government of Orissa and Government of India. In the light of this, the charges framed against me are not justified. Besides this, the performance of DRDA Hon'Ble during the year 96-97 was for better than the DRDA of the state. All these facts may kindly be considered sympathetically sworn.
Now kindly come to 1. Checks to be exercised. 1. You have taken a contention. Statement of account for the year 96-97 duly audited by the chartered accountant have been obtained and sanctioned. Where are the documents? They were certified by the chartered accountant as the law then stood. Where is the material? This is only saying, you are saying like this.
There
is nothing.
Department proceeding records may have a document. Your Lordship, kindly charge 1 has explained during the year 95-96 and 96-97, cement was being purchased by all the BDOs of Hon'Ble district of different brand at the rate of rupees 135 per bag. It was resulting in the high cost of the buildings. The construction of building was suffering. Nitin Chandra IAS Collector and Chief Executive Officer DRDA Hon'Ble advised me to reduce the cost of construction of building by procuring cement from L&T company at a lower rate. See,
no, where is the
advice?
Where is the sanctions for this? How could you buy so much quantity without
proceeding?
Without tender?
That's my call for the proceeding records. Must be there. Proceeding records.
Do you have the records for it?
No, not now.
So much time you are wasting there. There is nothing at all. He appears to be a rank criminal. He appears to be a rank criminal like Hon'Ble.
Let's kindly examine that matter. On the records, let's
AGA to secure a record of file of inquiry proceeding. First off. From next week we will call this matter because otherwise we will forget whatever we have heard now.
My lords, next week will be very short.
Week after next we will do.
2 weeks after this.
Yeah, 2 weeks. Feeling which some adverse order may be passed. Okay. Item 30 against the officials of the government. Yeah.
This entry motor was there. Now he has died.
He is dead now.
This will be in the second order. Sorry, in the second case. This order may not have done.
Entry order to continue till next date of hearing. Yes.
33, my item 33%. For my learned senior starts, I am for the Union of India opposite party. Lordship, kindly have a class to order dated 27/2/2023 and 25/6/2025. By both the orders,
My learned senior took time to produce the records. Last two orders.
Yes, sir.
My lord.
You will not comply with the order.
Yes,
Why petition should not be dismissed?
My lord, I have complied.
Complied?
Yes, my lord.
Very
This is your notice. Notice can be seen. Noting. I have directed to produce the writ petition filed before the Calcutta High Court. And I took time. And subsequently, second order was there, and I obtained the certified copy. Xerox copy of the same has been filed before my lord, and also copy has also been served. This is the copy. Yes, madam.
The copies are in our document.
Part C.
Flag C.
Noting is there.
That C is not before us.
देखिए नोटिंग का अच्छी दिसंबर मासेर फाइल है
Do you want one more set of copy?
Yes, my lord.
Give that copy.
No, the copies are also not available with me. I will collect from my office.
Huh?
He has served the copies to my office. I will collect them.
Give one more copy to him so that he will read and come back. Otherwise, previous case happened, na? 35 minutes spent on that only.
I will give.
Counsel for the petitioner to serve the copy of the writ petition and other documents. As mentioned in the coordinate bench order dated 27/2/2023.
26.
Last hour is 23. Second at 20.
The second order is there 25th, 6th, 2000.
No, that repeats only.
Yes.
Follow week after next.
May I submit, my lord, one thing?
Yes.
The petitioner is a 92-year-old. So your lordship may on next week.
Next week, we have already posted many matters.
Then
week after next, 2 weeks.
After 1 week, my lord. But we will still admission.
Yes.
Just have a 92 waiting for my life.
It will come in the same. Yes.
Obliged.
Item 34.
I'm on petition. Your petition ballot challenges a part of the order of the tribunal ballot. Termination order was set aside. And the director reinstated 50% packages. I challenge that 50%. There is no justification to deny full package. I am entitled to full packages, my lord. That part I challenge, my lord. I support you will also see the last order dated 9/12/24, my lord. Order number 5 dated 9/12/24. 9/12/24, my lord. Now, relying upon number of judgments of the Supreme Court, my lord, when my termination order is set aside and direct administration, normal rule is with full packages. It is repeated, some reasons have to be given.
How long you were out of service?
2017.
Date.
The order is
21/8/2017.
May Christmas order.
Up to
my lord, the order. Tribunal passed the order on 25/6/2021. 2 months thereafter, I was administered, my lord. I was administered in August 21, in fact.
reinstated on?
Exact date I don't know.
August 21.
I've paid the full back. I received the 50% back with my lord.
Your case is that you should be given full back wages.
Yes, ma'am.
You were removed from service.
I was, ma'am.
Dismissed from service.
Dismissed from service.
On what ground?
On the ground of misconduct on first onward, and a criminal case was registered, my lord. I was acquitted in criminal case. Also, the department proceeding, the misconduct ground was disapproved, not proved in the inquiry proceeding also. In the department case, it was not proved, my lord. By disagreeing with the inquiry report, my lord, the authority passed the order.
Who appeals for the other side?
Union of India.
What do you say? The criminal proceedings ended in acquittal. Is it honorable acquittal?
Honorable acquittal.
Show that. Or benefit of doubt?
No, honorable acquittal. Judgment is page 47, my lord. Page 47. It starts from commencement page up to page 52.
No. Where it is stated?
Yes, ma'am.
That Ramlal factors have to be stated. Then it becomes acquittal, honorable acquittal, not otherwise.
Prosecution could not prove that case.
That is not, in all criminal cases, they say like that only.
That is okay.
To say, take out that P.V. Rudrappa. 5 circumstances have been enumerated.
Yes, ma'am.
If your case fits into any one of the 5, then you are entitled to full back wages. Not otherwise.
I am relying upon
2015 Supreme Court you are relying upon. You go back.
I am relying upon 2014 Supreme Court also mainly on Dipali Gundu 2013 volume 10 SEC. I have given that in my writ petition.
No. When there was a disciplinary inquiry and also the parallel criminal proceeding, the charges were framed against you.
Yes.
You entered, the prosecution entered the witness box. Is it?
Yes, ma'am.
Therefore, trial took place. Then you are acquitted.
Yes, ma'am.
Unless one of the 5 points which are discussed in P.V. Rudrappa, go to that P.V. Rudrappa judgment. That is not the
P.V. Rudrappa.
P.V. Rudrappa versus State of Karnataka. Here is. The accused is falsely implicated to seek vengeance or for some ulterior motive. Whether such a sentence is there? No, it is not there. There is absolutely no evidence to implicate the accused in the proceedings.
It is
that sentence is there?
Yes, ma'am.
Show that. Or prosecution has miserably failed to prove the charges against the accused. Or 4th one, the prosecution witnesses are unworthy of any credit and their version does not generate any confidence.
Well, page 50 of the...
Unless these one of these factors present, you will not be entitled to full back wages. Page number?
Page 50, my lord.
Go to 50.
50, paragraph 7 of the trial court judgment. Also got it, my lord. Page 7 and page 7, 8, 9, my lord.
We also heard that a lady attempted to commit suicide with her child by jumping into the canal.
Yes, yes.
He rushed to the spot and found the accused was sitting on the canal embankment and was crying. PW7 reports the matter to police and proved a FIR while exhibit so and so is a hearsay witness. 9 ASI, the death of one Sri Sriyamanti, child of 1 year old. During inquiry, he examined the medical officer, then the dead body of the child to the district headquarters hospital
conducted inquest. Through the inquest report, husband of the accused is a post-occurrence witness. He deposed that the accused left house on petty dispute, received a phone call from so and so. He went there and came to know. Right, the medical officers, right, from the evidence of public affairs that none of the witnesses had seen the accused throwing the child to canal and jumped to canal to commit suicide. The accused pleaded that the child went to the canal for which she jumped to the canal to save her child. The plea of the accused appears to be probable when none of the prosecution witnesses had seen her throwing the child to canal. Well, your client is this lady.
Yes, mother, my lord.
Mother of the child.
Mother of the child. Because she actually she jumped to save the child. Child is asleep, my lord. She saved the child. But child could not save. The local people also. It's a busy place, my lord.
Which mother will throw the child unless she is a candidate falling in the rule of McNaughton's rule of madness, insanity? Which mother will throw the child to the canal unless she is a mad, insane?
That is.
Presumption is mothers protect the children. Since God could not be there, He created mothers to protect the children. Unless there is some material to show that she had intentionally thrown the child into the canal, which no mother will do. There has to be very strong evidence for that. And not even one person is an eyewitness. All post-incident witnesses. And of course, the learned trial judge has not drawn proper presumption under section 114 of the Evidence Act. He should have drawn. Why she should be? She has lost a child. She went into the canal to save the child. That appears to be very probable.
It's really embarrassing. But section 114 of the Evidence Act regarding conduct of a party, conduct and business, all those things are to be taken into consideration. Here, the intention of the party must be seen. She doesn't want that her child should be killed, but at the instance, at the spur of a moment, she was trying to commit suicide along with her daughter. This presumption cannot be ignored. That can be refuted by other evidences.
Where is that other evidence?
My lord,
that charge is not proved at all by you.
My lord,
in the disciplinary inquiry. You have not written the
verdict. Subject to your lordship's consideration. Page 51, your lordship may kindly see. Under probability, my lord, the principles of beyond reasonable doubt, that was perhaps taken into consideration, saying that other witnesses are not seen all those occurrences place when this occurrence took place. So that is why, on the ground of probability, she was acquitted. Was subject to your lordship's consideration, my lord. All those things are mentioned here. That is why I am saying.
See, you are wrong. You are not even wrong. You are beyond that. Para 9, read 9, para 9. Not even one single witness has deposed that he was there when they saw. All hearsay. All that person said, this person said, so happened. Where is one single eyewitness is not. On the other hand, the accused takes the stand that I jumped into the canal to save the baby.
But that would be, my lord, then matter is something different. That has not been sufficed by himself being, he could not prove all those things. As for saying, this has not been mentioned in the judgment.
No, you are wrong. Kindly come to paragraph 9. Read 9. The plea of the accused appears to be probable when none of the prosecution witnesses had seen her throwing the child to canal and jumping to the canal to commit suicide. There is a finding.
That cannot be. That is there.
And in prosecution, criminal jurisprudence, the burden of proof lies on the prosecution, although the onus shifts. Even shift has not happened here. Number one. Number two, to take up the defense, the accused need not enter the witness box.
She need not enter the witness box. Thirdly, there is a strong presumption that no mother will abandon the child, let alone killing.
No, that is correct.
There is such a very strong presumption. Take out that judgment of pre-counsel. Order. Of course, that judge has not discussed, but we can gather from all this which mother will throw the baby into the bathwater, let alone the river.
No, that is correct.
No baby will be thrown that way. Unless she herself has insanity, medical insanity, legal insanity, McNaughton rule, etc. Number one. Number two, in the disciplinary proceedings, where have we recorded the finding of guilt? You have returned a finding in her favor.
That is also correct.
That's true. If that is so, how can you say that you will not pay back the wages? Because of your fault, she was kept away from the employment. It was a compulsive removal from the employment. And that has been found fault with. Then why she should be punished for that? She has lost the child. And she was out of the employment, fought one criminal case, fought one disciplinary inquiry, and secured victory. Then you have to pay. You make it 75%. You make it 75%. That way we will do that.
Yes, my lord, my conscience also, as your lord.
So I said that you argued.
No, I cannot argue on those. My lord, against this finding, my lord, I cannot argue because my conscience.
You are more than fair. Right now. The petitioner, it's a petition, na?
Petitioner, one.
The petitioner has secured an order at the hands of the Orissa Administrative Tribunal.
Central
Administrative Tribunal. Partly favorable to her in the sense that reinstatement was ordered with 50% of back wages. Can you be seated? Sit and answer. She is knocking at the doors of the court, pleading against denial of remainder of the back wages that has accrued arguably in her favor during the period between dismissal dated 28/8/2017 and reinstatement while impugned order dated 25/6/2021. First time. Next paragraph. Learned counsel for the petitioner vehemently argues that in the disciplinary proceeding, nothing has been recorded as to the charge of throwing the baby, her baby, into the canal for causing its death. And the criminal court, having acquitted her wide order dated, which is that order?
30th September
2019 in what is the CC?
In city case number.
In city case number
3/368 of 2016.
And so, comma, she was out of employment for no fault of hers, and therefore the tribunal is not justified in not awarding full back wages instead of half, 50%. Next paragraph. Next sentence. Learned counsel, CGC, sit down, sit and answer. Appearing for the OPs
opposes the petition, making submission in justification of the impugned order of the tribunal, and also drawing attention of the court to the observations made by the criminal court in the subject criminal case while granting acquittal. First one, he submits that in a sense, no work, no pay principle becomes invocable in the case, and therefore the petition is liable to be negative. First one. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant a limited indulgence in the matter as under and for the following reasons. Number one, the first charge of throwing the baby into the canal, throwing her baby into the canal with intent to cause its death and to commit suicide has not been proved. First one. The criminal court in the subject criminal case acquitted the accused, that is the petitioner herein. First one. At the paragraph 9 of the acquittal order, it is observed as under. First one. That is at the 51 page. Next paragraph. It is said that God could not be everywhere and therefore created the mothers. First one. There is absolutely no material to infer, let alone demonstrate that the petitioner intended to commit suicide and as a preparatory step for that had thrown her baby into the flowing waters of the canal. First one. No mother would hurt her child. First off, Adi Shankaracharya in his Viveka Chudamani says, Kumata na bhavati. There shall be no bad mother, literally meaning. First off, there are decisions of civilized jurisdictions which hold that mothers have tremendous instinct to save their children, come what may. First off, such a presumption can be drawn under section 114 of the Evidence Act, Erstwhile Evidence Act 1872, regard being had to the timeline of the case. Yes. First one. If that be so, it becomes ununderstandable as to how full back wages would have been denied by awarding, that is, by awarding only 50%. First off,
Next paragraph. The contention of learned CGC that the principle of no work, no pay is invocable in the case at hand cannot be agreed to. First off, it is not that some charges were framed against the delinquent and thereafter the same came to be questioned by the competent authority, court or tribunal. First off, the disciplinary authority himself recorded a finding of no guilt against the petitioner. First off. But during the proceedings, she was kept away from employment. And therefore, in that, there was no element of volunteer attributable to the petitioner. First off, in such a circumstance, ordinarily, the rule of no work, no pay is not invocable. First off, thus there is an infirmity in the impugned order of the tribunal. First off, next paragraph. Next point. All the above being said, there is nothing on record to infer that the petitioner was in gainful employment. First off, there is not even a plea taken up by the OPs, respondents, as to the gainful employment of the petitioner who has lost her baby in the conspiracy of circumstances. First off, keeping all the facts and circumstances of the case, we are of the considered view that 75% of the back wages instead of 50 would have been awarded to the petitioner. First off, come on, by balancing the competing equities. First off, next paragraph. In the above circumstances, this petition succeeds in part. The impugned order of the Central Administrative Tribunal, although in substance is kept intact, is marginally varied to the effect that the petitioner should be paid 75% of the back wages instead of 50%. This payment to be made within an outer limit of 8 weeks, failing which the same shall carry interest at the rate of 1% per mensum for the first month of delay and 2% for the period next following. First off, the interest component shall be recoverable personally from the erring officials of the department who caused delay in implementing this order. Okay.
My name may be reflected in that. My name may be reflected.
Yes, show his name.
Yes, yes, sir.
Let's see. Yes. Next matter. Your thickness of your file threatens us.
Well, in fact, I have prepared a convenience compilation. So your lordship may only refer to that. That is about half an inch thick.
Half an inch?
Well, the sole point is, there is a OPSC conducted an interview. Person securing less mark, continuing in service, whereas the opposite person
who is having more meritorious candidates
have not been selected, whereas less meritorious candidates are continuing in service. After hearing for a substantial time in different benches, your lordship once heard this matter also. After the bench was, your lordship division bench became break. Thereafter the matter was taken up some other court.
Myself and Sausa.
Yes, sir.
I remember.
Thereafter, I have tried my best several occasions, but the matter could not be reached there.
Sometimes our efforts do not bear fruit.
That's why, can it be taken up so that it can be disposed of?
Yeah. We will have this matter on 27th.
27. Problem, friends.
All right.
Can I pray some preference to this matter at 2 p.m. or at first case or anything else? 2 doctors are deprived of since 2018. Even if they have, the Honorable Single Judge has directed, and one of the Honorable Division Bench
at 2 p.m. So that it will reach at 2 p.m.
But there is a convenience compilation. It's 45 pages only.
45 pages only.
Compared to the brief mail, it's a relative comparison.
I have prepared only 3 pages. Should I hand over?
Yes, give us so that we may also.
Only 3-4 pages. I got a copy.
45 pages only documents, not no submissions. Only the documents I've extracted.
You have extracted that?
Yes, ma'am. So it's a convenience compilation.
Do you dispute that his clients are more meritorious?
Less meritorious candidates, my lords, have been appointed, but the fact.
Question is not that. We are not asking you whether less meritorious candidates are appointed. Our question is specific. Do you dispute that your clients are less meritorious?
I am the Odisha Public Service Commission.
You will be doing this.
Yes.
You are the right person to answer that.
Yes.
My lord, even this honorable court directed them to file an affidavit. They have filed an affidavit. The last candidate secured 80 mark. More meritorious student, about 43, securing more mark than the last cut-off mark, are deprived of from continuing.
The fact, yes, it is true. Yes, but the facts are such. In fact, presently the petitioner is seeking a negative equality. I will demonstrate it from the facts.
Not negative equality.
Same interview.
Same. He says, my clients are more meritorious than the selected candidates. Therefore, we should be accommodated after removing them. That is his case.
We have no. So, what has happened is there are 2 select lists. The first select list appointments were made. There was a revised select list. The petitioners are there they are not there in either of the select lists.
That itself is the grievance.
Yes. They have not cleared the cutoff marks either in the first cutoff marks or the second cutoff marks. But by virtue of time, the persons who had been appointed under the first select list, they are continuing in service.
No, therefore he is here.
He has secured more marks than those persons. However, as per the revised cutoff marks, he has not secured the cutoff marks.
No, the revision itself is wrong.
I will show you, lordships, why that revision is correct. In fact, the revision was made at the instance of the petitioners.
No, there is no such direction for revision.
I'll show you, lordships, everything.
Okay. Rest of them, just distribute them to the other.
Nota deliberate.